happened during the course. So when we first had the indictment read, it was more than just the 6 that are
Was
present
it
in the
all,
court.
whatever, 19 of them?
With the exception of maybe
Yeah.
the ones that hadn't yet been apprehended.
Yeah, so everyone was here except for,
And everybody at that point in time was on trial together?
yeah,
Okay. I mean, it's been a long time.
except for the ones that pled and a few that were not apprehended, yes.
The ones that had not had attorney.
Huh.
Some that had not been apprehended. So there were, I
So,
think 6 that weren't.
so Mr. Kitchens is indicted. He pled guilty around Thanksgiving of 2023. The jury first came upon us January 4th, 2023. So I made a mistake. Mr. Kitchens pled guilty under Alford in November of 2022. Mr. Arnold did the same. Mr. Sumlin did the same. Mr. Stevens did the same. Mr. Murphy did the same. Mr. Sledge did the same. Thank you. And I should look at the indictment for more. Mr. Garlington never had a lawyer, so he was already removed. Mr. Wani Lee pled guilty around the same
Who
time.
was that last one?
Mr. Wani Lee, L-E-E,
okay.
and Wani is W-U-N-N-I-E.
Yeah.
So, the stage, I'm sure it was a miscalculation, but these people were already all included in everything in the indictment, but were not on trial before the veneer panel was first put upon us. And if I left somebody out, Mr. Eppinger was with us for jury selection. Then he got, something happened and he got removed after that. So he was in a different category. Mr. Blaylock pled guilty after the veneer panel.
Mr. Blaylock has not pled guilty. Mr. Blaylock was severed as well. So I believe I said everyone who had not pled and not been arrested was present. So there were individuals who were severed subsequently. So Mr. Blaylock was severed after the jury was impaneled.
That's true.
Mr. Dorsey was severed. Ms. Eppinger was severed. Mr. Mender was severed after the jury was impaneled.
Right. So the people I mentioned pled before the veneer panel was read the indictment. And I'll look at the indictment. There may be a couple more, but that's my memory. Mr. Winfrey was severed before we did, he was apprehended, I think, afterwards. So name was read to the jury, but he was never with us.
So if they had not pled and they had been arrested, they were all on trial. And so obviously those names were read. Were the names of the people who hadn't been arrested and hadn't pled been read? Were they read? So everybody's name was read. Okay. And I don't know if there were any counts of the was every count of the indictment read? Even if it was only against somebody who had already pled?
Yes, sure. Because I think it was pre-recorded, and so everything was read. To answer your question, yes.
Okay. Was there any objection to that? Okay.
When the court says objection to that and there's a yes, get clarity, because on the yes.
I mean, honestly, at this point, that'll be a motion for new trial issue if it gets to that stage. I'm just trying to figure out what this jury has heard. Y'all would not intend to send out an unredacted indictment if we get to deliberation, right?
we had actually talked about redacting the indictment. I think we were
Okay,
actually,
all right, well, good. Because I don't think an unredacted one should go out. All right, anyway, back to what we were doing, so I mean, the question was with regard to people who are not on trial here now with these 6, is there any kind of objection to those people being mentioned?
Yes, so I'm finding Bruton under conspiracy
Yeah,
and directly impact, and that's what I have to get to the court.
okay, all right, well, why don't we circle back on this one then? Because that, obviously what the law is will determine what the answer is.
and
So it's definitely out with regard to naming anybody on trial here other than Mr. Kendrick, but with regard to anybody else,
it would,
TBD, depending upon what the law says about that.
yes, Your Honor.
Okay. So y'all get the next one lined up and let me jot myself a note on that. Okay, I'm ready for the next one.
So 10205, so Mr. Kokomo, you'll orient us earlier and what's going on here, Your Honor. Detective Gaither is asking, this is at 10055. So then after Woody got jumped, you know who Woody is? Who shot up the studio TIG? Mr. Kendrick states, I don't know. Mr. Gaither said, I heard your crew shot up TIG after Woody got jumped on. There's a discussion of where is TIG? Then Detective Gaither says Metropolitan, like over there by Thug Studio. Mr. Kendrick asks, where's Thug Studio at? And then they talk about that location. They talk about YF and Lucy. And then at 103, Detective Dennis say, you still on Bloody J when he got locked up, and it goes on to that event. And
So is this just because Mr. Williams' studio is
Well,
to orient people to where things are?
well, at 102, it's just about the studio, but I was targeting the RICO conspiracy. So I was targeting the, this is where, actually, I'll withdraw that because
Okay.
it does not mention, I apologize.
All right, no problem.
All right, number 105:19, 1:05:19, Detective Dennis mentions Mr. Williams' quote unquote girl regarding a shooting, supposed shooting of that event. And that is it's 104:32. Detective Dennis states, didn't you catch them down bad? That's a reference to Mr. Kendrick's music. They laugh. It's a verse in a song. And then Detective Dennis says, so who shot up Thug's Girls event? Or did you hear about that? And Mr. Kendrick says, I don't know. That's my first time hearing about it, so I wanted that excluded.
What's the response?
Doesn't, number one, evidence of that has already come in through Dennis, but number two, that in no way inculpates Mr. Williams in anything because it references
His
Him as-
girl being a victim.
Right.
Okay, yeah, I mean, I don't think that's a Bruton.
So my issue with that then would fall back on a different issue then. What's the point? The answer is, I don't know anything about it, so we're now
Right.
just using
So
the
now we
question.
have a relevance objection. No, we'll do them all at the same time, so
So,
we don't.
I don't have a problem not having him since he doesn't know anything about it, keeping that part out. He said, I don't know
Okay.
about that. I don't have any problem keeping
All
that
right,
part out.
thank you.
Next is 108, 1:08:40. And this is the part you heard earlier that may be stipulated to. Mr. Kendrick mentions Mr. Stillwell telling detectives who, quote unquote, they.
Right, and on that one, what would be permissible to ask about is that at around this time,
They were beefing. with
our crew were beefing with
them.
the other group. But not anything about the rumors or anything like that. So that one I think is clear. Okay. Next one.
The next, Your Honor, will be it's really the same flow, but it's 1:08:51, so it's only 11 seconds later. And Mr. Kendrick, mentions Mr. Copeland sharing that he was tied up with Mr. Stillwell and specifically, and then Mr. Kendrick identifies a photograph 8 seconds later of Mr. Stillwell. Then Detective Thorpe mentions Mr. Stillwell and clarifies that the word is that Mr. Stillwell and Mr. Copeland killed Mr. Thomas. And Mr. Kendrick speaks to that.
We
And that-
don't have any intent to bring that out.
Any of that?
Right.
Okay.
Okay, the next is 1:11:30. And it's Detective Gaither mentioning that Mr. Stillwell is the person that whoever everyone is, brings up related to the murder of Mr. Thomas.
And this falls in with what we initially said, that when they were talking about who they said killed Donovan and bringing up Mr. Stillwell's name, we have no intention of doing any of that.
Okay.
Okay. The next one is 1:13:44. And it's Detective Thorpe, I believe.
All right.
And he says, people talk to you in the city, all put you four involved in the murder of some kind. Mr. Kendrick denies it, says they are lying. Detective Gaither says, you think anybody going to tell the same story? Mr. Kendrick asked, what did they tell? Detective Gaither said, I heard you was in the car. Mr. Kendrick said, what car? Detective Gaither said, the Infinity rental from Thug. And then Mr. Kendrick said, no, I wasn't. Check whatever, my phone, whatever you want to check. And then Detective Gaither says, we did. It was said a whole lot. And then they go off on that. So I was objecting to Mr. Williams or Thug being mentioned.
Your Honor, that whole, all of that colloquy is part and parcel of them talking about who people said killed Donovan Thomas. Anytime we're talking about any of these defendants being rumored to have killed Donovan Thomas, the state has no plans to get near that part. Now, Mr. Kendrick denying that he was in a rental by Mr. Williams, we would proffer that type of information because it would not inculpate Mr. Williams.
Yeah, I agree with that. I mean, I think it's already in evidence that Mr. Williams rented an Infinity, right?
Yes.
And up for dispute whether that was involved or not.
Right.
But saying, the Infinity that he rented doesn't inculpate him directly. So that I would be okay with. I mean, I don't think there's a Bruton violation if you ask or get an answer that talks about the Infinity that Mr. Williams rented or that Thug rented. Okay.
The next and I'm skipping based upon what the state just said about that whole colloquy.
Okay.
So it would go to 1:18:31. And that's after 1:17:35. Mr. Kendrick reaffirms he has nothing to do with the murder of Mr. Thomas. And then at 1:18:25, Detective Gaither asks about NARD, NARD, and DUWOP, DUWOP, where they are now. And Mr. Kendrick explains a lot. He's almost questionably locked up. And then the target event, Your Honor, is Detective Gaither asked from January 10th until today, how many times do you think Shannon been locked up? We'd like that redacted.
My apologies for leaving that out. I would not put that in.
Okay.
Okay, the next one,
The part about Mr. Stillwell being locked up, the other
Right.
part, yeah.
Yeah.
the next one is 1:21:25, Your Honor. And at that point, Mr. Kendrick had shared with the detectives that he went to Miami after January 10th. Detective Dennis asked who all went. The answer by Mr. Kendrick is everybody. Detective Gaither said, who is everybody? And then Mr. Kendrick starts naming little d, everybody. And then Detective Dennis points to the photograph of Shannon Stillwell. Mr. Kendrick says, yes. Says, yeah, actually, Y-E-A-H.
Okay.
So that's the part that we were taking out, the picture and the pointing.
Well,
This is just him saying, here's who all went to Miami.
Yes, immediately after
Doesn't
the killing.
inculpate anybody directly in anything. It might
Okay.
be argued to be a part of the evidence, but that wouldn't be a Bruton violation.
Okay, we're just raising objections then, if that's okay. And when I say okay, I'm not waiving anything.
I understand.
Okay, thank you. I said okay, but thank you.
Yeah.
All right, the next one is going to be included. Did Thug went? Was a question by Detective Gaither. The answer is yes or yeah, so I assume it's the same ruling.
Yeah.
The next one, Your Honor, would be and I assume it's covered by your ruling. Detective Gaither asked Mr. Kendrick, how long did Mr. Williams stay in Miami? So I'm assuming it's the same ruling. So I'm moving on from that one.
Okay. So the one about before that 1.23.06 about Mr. Stillwell getting calls.
Yes, I should have included,
That
I
doesn't-
skipped that one accidentally.
And what'd you say, Ms. Love?
I'll let the court decide on that. I'll let the court hear that, because I didn't count that as inculpating, because everybody was, what he's contending is that people were calling, but I'll have to hear that part again.
Okay, let's just
because
hear that. I'm not sure what it says and
Start at about 1:22:40 if you can, Mr.
Okay.
Kokomo. And what it should say is, it should be Detective Dennis
Okay.
asking about what conversation was like on the way down to Miami. Detective Dennis specifically, I believe, said, Your Honor, the ride down had to be some type of, just like you just said, like when Duke got jumped on, people started hitting your line. So y'all started to get worried, and Mr. Kendrick said, it wasn't on my conscience. And then in there, they talk about Mr. Stillwell was probably getting calls.
all right, let's just see.
One of the conversations, everybody just sitting there like, yeah, that was just stoned with. Like, I get my own spring, I'm art. So. Right, but what I'm saying is, the ride down had to be some type of. I don't know, because it's just like you just said, when Duke got jumped on, people start hitting your line. Yeah. What's going down? So y'all had to start getting word that these names are out there as nuts that got killed. Yeah, but they're like, it went, yeah, they probably got getting like calls and saying shit like they think it was them, but it wasn't no matter country or folk wouldn't call me. Like, yeah, you know what I'm saying? They want. But if they're your people, it's almost like you're guilty by association to an extent where if this not.
we wouldn't have any problem taking that whole last 2 or 3 sentences out. Like, they were probably getting calls thinking it was them, and then Dennis saying, well, it's your people, you guilty by association. Like, those 3 or 4 lines, we don't have any problem coming out.
All right, does that cover it?
Yeah, Mr. Kendrick, I'm sure it covers it. Specifically said Shannon, so I'm assuming that's it covered it too.
Let's make sure.
Yes,
Okay.
yes, yes.
Okay,
Excuse me, Your Honor, we take 5 minutes before we continue down the list.
sure. Yeah, that's fine. Let's take a quick break.
Thank you.
Sure.
Okay, I'm going to remove that from the screen for a little bit while they take a break. This is a different type of trial. As I stated in previous videos, when election time comes, they have to get a big fish off the street. And to be honest, the person who's the head district attorney and other higher officials want to, make like basically Thug is considered a millionaire and they feel like he's out of control. But, they do this every time it's election time. You know what I'm saying? Every time it's election time, this happens all the time. You know what I'm saying? So, I mean, I don't know what just happened. Oh, okay. Sorry, the screen looked like it went black. But it's like election time. This has been going on for decades, you guys. And you have to see where the patterns, how the patterns are. Every 4 years, they're going to have big major trials. Every 4 years, they're going to promise you stuff that they will not do during the 4 years. Every 4 years, they're going to try to pass certain little bills to make you feel good about yourself. I seen on the YouTube, I know it's off the trial. I seen on the YouTube where they have people, not YouTube, they have officials that are going out in the offense for, what are they, Kamala, whatever her damn name is. I'm sorry, I'm not voting for it. I mean, people can get mad if they want in reference to me not voting for her, but I'm not voting for her. It's what it is at this point. It's finna be a battle to the fittest. They're finna do a lot of mudslinging or whatnot. If Georgia lose this case, let's get back on track. If Georgia lose this case, it's just gonna be, it's gonna be a shame. They took your tax money and I'm waiting for the trial to start back. They took your tax money and they spent it on hours and hours and hours of testimony. Y'all, I swear to God, I done been to court in my younger days a lot. I have never seen, they dirty, but I have never seen this level of dirtiness ever in my life. For to want something so bad, it's like you cannot, no matter what, you cannot dismiss this because we have to get him. And they just do it. Like, if you've been in that lifestyle, which I have, and I hear people say all these things about what is a rat, he's this, he's that. When you have a guy that is a killer, he has no respect for nobody. Eventually, either the person that's dealing with him, that person will eventually have to outsource him and get someone else, because sometimes killers, their head get bigger than the system. I call it a system. That means bigger than the person that's paying them. So therefore, they doing work for him. They're doing work for others. They're doing work for themselves. It gets big. You know what I'm saying? And when I was on, what is that guy name? Attorney. He says this little. He always say the lead attorney, and I like him. he's always bringing facts. He's helping people, change their lives like he changed his life, which is a good thing. However, I did hear a young man say that he went and did the time, blah, blah, blah. That was the 80s and the 90s. I'm more than sure. And they wasn't giving you 10, 20, 30, 40 years. Like, boom, you know what I'm saying? They started doing that more when those Clinton administration, that's when a lot of people was getting 15 to 20 to 40 years, no hesitation. The streets is way more loyal. Nobody talked. Majority of the time people come home. You know what I'm saying? So now it's not like that. They're throwing these young people in. Like, just imagine being considered an adolescent. You think that you're a thug because Boosie said, like, you're OG at 25. I'm like, God damn, you just turned 18 and got up the mama porch. And you still hound your mama at 19, 20, 21, ask for questions, advice, XYZ. When we were younger, we had to figure that shit out. Like, it was like we got it out the mud through all type of trauma. We had to just figure it out. You know what I'm saying? But I know that we might
Lee's new spicy
crazy
wings.
or
6,
whatever.
12, or 20 delicious reasons to get.
Sorry about that. I should have just taken it out, but I got a commercial hit in there. I know they're gonna take it out, but it's all good. I just think that looking at the trial, I know for a fact that Willie went up in there lying. Y'all got to understand, Woody had a problem because not only they were trying to hurt him, they were hurting his trying to get at his baby mama and family members and stuff. And now his family members are on his head for all the stuff he possibly even did in his life. So obviously he's going to sit there. Obviously he's going to say more things and everything they want to hear, because he probably be okay. Like, if I die, I know the life I live. However, I don't want to see my baby die or my baby mama die. Like, this, the new generation, they get involved. Like, this is how you end up in jail. I'm just keeping it real. You start effing with the mama, daddy, brother, cousin, all these people that have ish to do with it. The only time when I was coming up that someone really attacked a mother, father, whatever, because they were involved with whatever that person is. Not that, and I say involved to the point where they egging it on or doing XYZ. A lot of parents didn't know their children was doing certain things in the streets, and then they knew, some of them knew, but they couldn't control their child. You know what I'm saying? But nobody would go in and try to kill your mama. Like, mamas was off limits. Children, grandparents, stuff like that was just off limits. Whatever was happening in the streets, they dealt with it in the streets. I've seen a few drive-bys, but there were like parties. Like, we know this crew is here, we're going to shoot it up, and the people who's there know that we're beefing with them and they have no business being there. But I have never seen someone get so mad but once in my life. I think it was just one time because a dude did it to him and he did it back. However, but normally parents and stuff, they were off limits. But we can get mad at what all you want, but you shot up his baby mama house. You know what I'm saying? So he already on the outs. But what you think gonna happen? Even if he told the truth or didn't tell the truth, I think it was the truth mixed with lies. I think Thug was just the money maker, and he grew up in a hood around all these people. He became close to all these people, and he had the money to give them to get out of jail. That's what normally happens, and that's what the prosecution want to break up. Y'all got to remember, they calling all these people names. I promise you, if they find these people guilty, they're coming with more RICO charges in the state of Georgia, which, y'all, there is no way, if they do find them guilty, they're going to overturn this. They're going to give all this back. Like, this is the most wicked thing that took place publicly. There's no way. And y'all can think like this. I'm just kidding you. Y'all think that this judge is just denying. This is a game. All this is just a game. I do believe it's eventually going to be a mistrial. because I'm listening. Y'all not listening. She's asking about things that took place that shouldn't have taken place. She's asking about certain, she's asking things, writing it down, like just different things. And you see how she said, well, were certain people names called and it was not an indictment this before, when everything took place. And she said, she, I listen to what she says, okay, and whatnot. So we have to, we just have to just sit back, and I guess this is considered a circus, you know what I'm saying? Krishan and Blueface is in jail. This is our only entertainment right now. And I mean, Woody is funny as shit, y'all. I mean, if you take a plea bargain, they're telling you what to say. So when Woody say that a rat is a person that goes and tell the truth to knock people off, y'all, Thug is the only one he was talking to, because I think in his mind he was telling the truth about he didn't think that they'll go mess with him. And then I guess he realized, well, damn, they didn't build a whole damn case off of my lies. I done went to jail, came out. I thought like they didn't believe me because I was lying from the get-go. So you didn't believe my lies. So you still put me in jail. You still made me do time. Then allegedly, quote unquote, he didn't eat for the weekend. So if you're not feeding me, you're not allowing me to get calls, because they will do that too, you guys. And you see how nonchalant everybody is about it? Nonchalant about everything. Nonchalant how a detective was trying to flirt or do whatever he was trying to do with one of with the young lady that was on trial. Nothing has been done about that. Y'all done let that skate over your head. Y'all talking, like, if you're going to talk about corruption, like, y'all need to take this trial for what it's worth, because this is what people go through. And y'all keep saying black, like, y'all, white people go through the same shit. Like, they really do. Like, it's just they publicize us. They want us to keep saying the word victim. At the end of the day, we can't progress unless we move around and stop worrying about who's racist and who's that. When you call white people out their name, they don't give a shit. They go home, sit with their homeboys and laugh about what you said. Meanwhile, you're on the internet angry as shit. You know what I'm saying? Oh, this needs to happen. Da, 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 da. You got all the black lawyers that will go. Y'all, let me just tell y'all a little story, right? And I watched my mom get killed, right? I didn't know that they lied on me. The prosecutors are dirty because people wanted money from these, from the death. The kids got nothing, didn't know nothing until kind of like now. When I tell you, for the breakdown in your 40s, it's just crazy. And maybe God knew. I shouldn't have known until I got into my 40s, because I probably wouldn't have been able to deal with it, because I don't drink, I don't smoke. Well, I drink a little bit now, but it got to be fruit drinks. But I don't smoke. I don't do any of those things. You get what I'm saying? So when I tell y'all think like the prosecution people, the DA, right? You think that they're good people. They are not good people. My mama got killed by a black man. I call that attorney that I always see online just for questions. That man wouldn't listen to me. He turned me down. You guys, I had to go to paralegals, took a paralegal course so I can kind of understand things. And my family was trying to get whatever what was left, and trying to say like we singled us out. I guess our mama part, but we had a part that we didn't know that was built on their house that they never paid us for. The head DA in Baton Rouge won't talk to me, won't say nothing, but y'all threw my mama away like she was a criminal. They lied on me and said my mama known for playing with guns. My mom she was married as a child, and my father was an old man. I didn't know that. See, let me tell y'all something. Look at your birth certificates. Understand certain things that you don't never pay attention to. When I went to look at my birth certificate, my mom was 15 years old. My daddy was 21 years old. You know what I'm saying? So when I just thought she was this super, super strict and willing me to go places, I understood. some type of way she was had to be molested or something was going on that she wanted to prevent happening to me. You know what I'm saying? So I understand everything that I thought I did. I thought I understood back then. I understand it now. So at the end of the day, you guys, these people, I'm a person that was a victim. Looked at the transcript. They didn't even, I mean, the findings. They didn't even tell the people my mama was pregnant. I just found all that out. She was 18 weeks pregnant. They didn't put none of it in it. They didn't put none of her kids was there. What woman pregnant with her kids around would be playing with a gun? It didn't make no sense. And it don't make no sense because it never happened. And I was there. They took the children out of element like it was them two playing. So I am working on it at the end of the day. And I'm just showing you an example how dirty these people is. You know, you move in an environment where you go from being an okay kid, learning stuff, also dyslexic. That's the biggest thing. That was the problem. They care less about the education part. My mama, you know what I'm saying? Like she did everything to put stuff in place for me. And life got tarnished. The system is not here for black on black crime. Because that man, by that man being black, I got turned down by every attorney in the world because they can't make a dime. They feel like they can't make a dime from it. But I've been studying and I'm getting everything together. However, they're back from break. Let's go back.
The next one, Your Honor, we are going to, I believe it's included in your honorable court's ruling. It's approximately 1:2539. Detective Gaither asked Mr. Kendrick how long Mr. Williams was in Miami, and he answers a couple of weeks. So I assume that your court said that that's not inculpatory, so I'm moving on.
All right.
The next one is, it's a visual. So if they're
Okay.
not showing the video at this, it won't matter.
All right.
But Detective Dennis points to the photograph of Mr. Stillwell and says he's all about that action. And they're talking about shooting people. They're talking about violence. So you may have to hear that, but and see it, but that's, we would object to that.
You're not going to use that. All right. States agrees. Well, they don't agree it's Bruton, but they're not going to be using it.
Okay. The next one is Detective Thorpe. It's at 1:33:55. Mentions Mr. Williams and how Detective Thorpe heard that people went to Mr. Williams' home after the killing of Donovan Thomas. You may have ruled because of the way you treated the rental car that that's not Bruton, but that's what I flagged.
All right. Do you think I need to hear it or is it pretty much?
That's pretty much it.
Okay. Yep. That would not be Bruton.
The next one is approximately 1:43:20. And I'm not so sure this is covered by Bruton, but Detective Gaither asked Mr. Stillwell if he drives a Volkswagen, but I flagged it. But if that's not directly inculpatory, I understand that, but that's what is said.
Okay. And this is just, does Mr. Stillwell or his nickname drive a Volkswagen? Yeah.
Yes. The next one is 1:47:18. Detective Gaither asks what was in its, I say Mr. Williams, but thug's demeanor when he pulled up to the McDonald's, and Mr. Kendrick says he cannot speak on that. So I assume that that's not under this court's honorable court's ruling. Anything we deal with Bruton. So I'm moving on.
Okay.
And if I'm waiving something,
No,
you
you
say
are,
no.
you are correct
Okay.
in your assumption.
And then the next one is 1:48:07. Detective Gaither asks, so that night, meaning the killing, you didn't meet up with Mr. Williams, and then ask the same for Mr. Stillwell based upon your honorable court's ruling, I believe that then we're going to skip. And if I'm wrong, please tell me I'm wrong, but
Does, what's the state's intention with regard to anything you might ask about that?
Given his alibi, we would, well, I don't know what, we would probably be
Asking that? Okay, well, yeah, I mean, I think that would be okay.
and then the next one is two. Well, it's really the same, Your Honor. It's clarifying the same thing. We didn't meet up with Mr. Williams or Thug and Mr. Stillwell, so
Okay,
that's it.
Yeah,
That would
same.
cover the entirety. Now, that's just for Bruton, but again, I will send to this honorable court, and there are cases on a RICO conspiracy, a conspiracy, and Bruton.
okay. I'll be on the lookout for that and the state's position on that also. All right, so we can circle back to going through the evidence that's going to come in with the next few witnesses, including Mr. Sprinkle. If y'all are ready on that, we can move on to the wiretap evidence that the state intends to use. We can,
the PowerPoint maybe is.
I mean, we can do the PowerPoint. Would the wiretap evidence come before the PowerPoint?
No.
in-
it would come
Okay,
after the
PowerPoint. All right, yeah, we can look at that. So everybody should have the kind of revised PowerPoint, I guess, that the state provided over the weekend, I think.
Easily run through it.
Yep.
And Your Honor, if I may just turn my back, you will get the thumb drive. Yes.
And so what the state sent over at this point would be, y'all have taken out everything that you don't intend to use. So the hope is for y'all that all of what you provided is usable, and we'll sort that out. All right. Yeah, so if somebody wouldn't mind, I guess, just giving us kind of a slide by slide. And I don't know that it needs to be displayed on Zoom as long as we're all looking at the same thing. That might be a better approach. So let's all just get our email that sent it over and open it up and look at the slides on our personal computers or laptops.
It was sent Sunday at 9:15.
Right. And was it a Dropbox link or was it an attachment?
It was an attachment with a PDF.
Okay, right. Okay. All right, is everybody ready? Everybody got it up? Yes, yes, yes. Okay. All right. Slide one, I don't see how the state could possibly need that slide.
No, that's not, no, I mean, it's not.
Okay. Slide one's out. Slide two, this is just sort of,
These are identifiers that they can use as identifiers that APD has identified, and
All right, hadn't there already been testimony about that?
there has been testimony about snakes and tattoos and red flags. Yes,
Okay, so that one's out too.
if you say it is, it is.
Huh?
And
I mean,
just to make sure we're all on the same page, what you're referring to as slide number 2 is the picture that has an arm with a
Yeah.
tattoo. Okay.
Yeah.
Which also coincidentally is the second slide in the attachment. That's what I'm going by.
All right. Just didn't want to make sure you weren't
All
looking
right.
at the title page. And then
Okay.
we're on the same page,
All right.
literally.
Okay, good. All right. Slide number 3. What's y'all's argument for needing that?
Okay, we can.
Because we've still got some language on all of this too.
So we can take out, we can take out all the language.
Mm-hmm.
We can take out all the language.
Okay.
Can you take that? John, may we be allowed to remove the Mondo board, the IT department?
Yes, that would be wonderful. We're not going to use it, so out it goes. So
Thank you.
y'all go ahead and, yeah.
Not right now.
Okay. What about these 5 pictures?
So the pictures, Judge, are just, as he's talking, he would
All right, so who are I see we've got
defendant Williams,
Mr. Williams, Rich Homie Kwan.
Bermian.
Are there pictures already in evidence of those
Yes.
3 people?
Yes.
Then use the pictures already in evidence. How about the bottom 2? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
Yes.
There is a picture of him in evidence.
All right, use that. What's the middle 5th one?
And this is defendant Williams. And
Is there
pre the gang, pre the dispute, the war,
Okay. I mean, is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
hold on one second, Your Honor. Have videos of the groups of
All right, so
persons
you could do a
together.
still from a video.
We
Okay,
can.
all right, how about slide 4?
This is just, Your Honor, and our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for what feels like ever. So they sort of know who he is. They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just put forth that there's,
Is there a picture of Mr. Watts in evidence?
Yes,
but
there
they're
is.
demonstrative.
Look kind of similar to this?
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that would cause either defendant to be in danger of being convicted of something or on something other than proof of the crimes we have listed in the
Are
indictment.
they going to, for some reason, be talking about Mr. Copeland and Mr. Watts together, that they're like,
Yes.
it's going to be crucial for the jury to see, here's Copeland and here's Watts?
Not crucial. But he will be talking about a specific interaction, specific.
Okay, well, he can
antagonism.
talk about that without this, and if you need to, like, have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence.
the gambling house that
Do we have pictures already in evidence of that?
knew.
Okay, then this one's fine. Slide 6. With the stack of money and obscene gesture.
Hold on. Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watts. So
Okay.
And we've also got video of him doing exactly the same thing.
we don't have that video.
Yes, we do. We've had a video and
All
tapes
right,
of
well,
him.
don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June. However, that was after 3 o'clock. And so we did not enter it
Ah.
again
Okay.
this time around. So I do not believe the video is in evidence. I'll double check,
Okay.
but I believe that was after
All
3
right.
o'clock.
Actually, good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay, this one's fine. He can use this one.
Can I inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts,
The flashing of the large sums of money.
not the flipping the bird.
I mean,
Yes, no?
the flipping the bird, I mean, it wouldn't have, our argument is that it's relevant because it shows Mr. Copeland with that huge stack of money that we're talking about, and it makes,
Is this the night of,
it's,
or is this
you
just?
say the night of, not
The
Donovan
night-
Thomas.
No, the night that the beef starts between he and Watts.
No, Your Honor, it is not.
It's just an example of him with a
Flipping the
bunch of
bird
money.
and holding money.
An exemplar. Good
It's-
word.
I think it's January the 8th. The 6th, January the 6th. So it was the night, it preceded it. That's the night that the fight started that led to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time.
This is a picture from the night that, it all got shot up or
I'll-
something.
I'll confirm, but that's what
After-
my understanding, that is January the 6th.
I don't know it's January 6th. What is that date?
I don't know. I don't know. Maybe they know what he was wearing to the
It's
club
the
that night.
detective that gave it to us, so.
My recollection is that he had different clothes on the night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night,
We
that's
will.
fine. Otherwise, it's just an example of, hey,
Well, not just.
here's what we mean about flashing money.
No, the large amounts of money.
Right.
I think during the course of the interviews that the jury has heard, you hear them talking about a very, very large sum of money.
Right.
And, one might argue or wonder, what kind of money, how much money did he have access to that kind of money? Him having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So the relevance bar is, of course, as the court knows, is a low
Yeah.
bar, and the fact that he's sitting there with that.
Okay. Well, he also is flashing the bird though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So maybe there's why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money. Okay. So we'll revisit that when we've got some more info.
Yes, Your Honor.
All right, slide 7. This just shows a couple of the, the Metro, but y'all, there's been testimony about the Metropolitan, right?
TIG studios that
Right.
Mr. Copeland is alleged to have shot up, or believed to have shot up.
We've had a number of crime scene photos ended of the Metropolitan. So there are a number of photos of that in already.
So it doesn't, there's nothing, if Detective Dennis is talking about this, putting it up doesn't take extra time. It just orients the jury as to what he's talking about. So it's a demonstrative aid that orients the jury, that is helpful to the jury, that is substantially similar to what that is exactly what he's talking about. So there's nothing that should
Okay,
preclude him
and
from showing it to the jury.
TIG is who's,
Think It's a Game
Right,
is the company that Rich Homie Quan was under, that Think It's a Game Studios is inside
Right.
that building right
okay.
there.
This one's fine. All right, moving on to slide 8. So this is several pictures of Mr. Thomas. We definitely do not need the Club Crucial Will Always Remember You part of that.
Okay.
And, you know, the language about whether he's a high-ranking member of a rival gang, I mean,
It can come out.
thank you.
But yeah.
I know it's asserted that he is, but this sets it forth like
Yes. it can-
fact, and
it-
that's for the jury to determine.
Yes, John. I'm just trying to X over everything.
Okay, so,
Did you have something?
I mean, those 3 pictures.
It's that feeling of freshly washed sheets. Cozying up on the sofa after a long day. Having all of your friends over for dinner. It's movie marathons and blanket forts. That first sip of coffee in the morning. It's that feeling of home. Lulu and Georgia bring beauty home.
So slide 9 shows just the type of
Are these actual posts already in evidence?
no, we did not.
Okay, well, if they're not, then I would think if you throw these up, that is more than demonstrative. So if you want to enter those as examples, we can talk
Okay.
about that, but
Okay.
otherwise he can just testify that here's what happened on social media after the death.
Okay.
All right, slide 10. Yeah.
I would be objecting to Detective Dennis saying this is what I saw on social. Okay, you understand that.
Okay.
It would
and
be hearsay.
because- And how would, well, no, what he saw on social media, he saw on social media.
If he's going to say, I saw on social media and someone posted the following, I'm assuming that's for the truth of the matter asserted. And the post should not come in. I don't know who posted it. It would have to lay a foundation for the writing.
So the fact that the posts were made and that they were publicly made is is the evidence itself, not that it's true. This death to the big homie sent the word
What-
out from behind the wall.
What would you have the answer generally be? I mean, what would you presume his answer would be, or your question and his answer?
Were there threats made against YSL in the moments, hours, days following Donovan Thomas's murder? Yes. There were public threats, social media posts, and the like. And these would be them.
Okay, well, that would. Okay, yeah, and that would be overruled because it isn't being offered for its truth. Okay, but we can just do that at the point in trial. We don't have to have this slide.
Okay.
So it slides out.
Slides out. All right, slide 10. Tell me, I guess, what I'm looking at and why he's going to be using this.
We can take this out. I think that this picture is already in any
Okay.
event.
All right. Slide 11. There's a lot going on this slide.
There he is. He can testify about that. It's basically it's Mr. It's the services of the victim in this case. So he can testify about it.
It's a good
Patient
question.
victim impact.
What would be the
Just-
relevance of how, many people were moved by his death?
Judge, if I may come back to the court on that, I can take out the slide and
Okay,
as to the questions about it.
all right.
So 11's out.
So the slide, yes, 11 is not going to be used, and she'll get back to me on the relevance of how crowded his funeral was.
He's very loved.
And maybe it is, I don't know, but. All right, slide 12. So. How about slide 12?
It's a similar one as the one earlier, so we can take out, we can take that out in the same way and introduce it if we need to. and-
Okay. Thank you. Is the picture with the placards from obviously some shooting already in evidence?
I don't think this particular one is, but it will be. We anticipate that this will be
Okay.
admitted in
Well,
evidence.
if you want to present it to him and ask him about it, that's fine.
Okay.
And the second one on there, do y'all intend to have him talk about that picture?
We can take that out.
Okay. All right, so then 13 essentially won't be used, and you can, if he can identify what's the crime scene photo, then he can testify to that. Okay, number 14.
Do we? So, Judge, we don't have to, with number 14, we would need to introduce, I think, the photographs versus putting it up.
Okay,
We would, yeah, as opposed to using it as a demonstrative.
okay,
There's
and
some
I mean, if they're
photographs.
already in, then obviously, if he needs to testify to them, he can, and if they're not in, you need to be able to, obviously, you need to be able to lay the foundation.
Right,
but-
and we may just get, some of the ones that are, as the court has already pointed out, some of the ones that are already in and put them on, just to use those as our exhibits with
Okay.
him.
Picture of him already.
I mean, presumably this shows everybody's, the relation, in a relation of these three people.
It does. He testified about that. It, but this is just like putting faces to the names and sort of family diagramming, and I think we actually did that earlier. So
Okay.
it would be referring back to something that's already.
I'd be objecting.
Then
Your Honor,
no.
the mother, if I interrupt, I apologize. If the mother of Mr. Thomas testified to family relations, the father of Mr. Thomas testified to family relations, and Detective Dennis testified. Now, he may not have, actually. He may not have. So definitely the parents, the mother and the father, I would be, it's just repetitive.
Okay, sounds like she doesn't intend to use this anyway upon further reflection. All right. Slide 16. We still have a current intent to use this slide.
We cannot use 16.
Okay. Okay, 17.
17. We can as well not use, so what, I think that what we'll do is just take some of the pictures, photographs that we've already admitted
Okay.
and use those as exhibits rather than trying
Okay.
to introduce whole hog. this
Sounds
PowerPoint.
reasonable. So 18, y'all still want to be using that?
No, we cannot,
Okay.
we cannot.
All right.
Well, except that I think that the photograph in the bottom right corner
Yeah.
were guns that were recovered. But I'll confirm with Dennis. I won't need so that might be something that we could use as an exhibit and not
Okay.
a slide. So if there's anything in this picture, certainly not the top 3,
Okay.
but if that bottom right picture, if we do anything, we would tender it as an exhibit versus trying to put it in on a demonstrative slide.
Okay. And these are all
It was the stuff that was collected from one of the vehicles.
from an alleged rival gang.
Yes, after the shooting at 1006 Hill Street. Actually, not the rival gang. This is the one that was collected from the people who were shooting back at the people who were shooting
Oh,
at
okay.
them.
All right. Well, I mean,
But
I can anticipate some potential objections from the defense at the point in time if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this is
Oh,
from
well,
the
we'll
other
see.
side. This is
We'll
the
see
guns
what the
from
strategy is.
the other side.
We'll see.
Okay.
Okay. That's what makes trials interesting.
So 18 is out.
18 is out. 19.
19, we have not yet introduced that photograph, but I think that
The one on the bottom, or?
yes,
Okay.
the one on the bottom. Part of that photograph is part of what was talked about in the interview with Mr. Copeland that has been shown to the jury so far. So we could definitely take out the words. We'll do whatever the court instructs, but that photograph, we can introduce it as an exhibit if it has not already been admitted, and we cannot publish the PowerPoint slide.
Okay.
And in that vein, Judge, with respect to, since we're going through it like that, rather than introducing, no, I think maybe we should. I was going to say, rather than introducing the whole thing as just, here's his demonstrator that he's using, since we're cutting it up and using parts of it, rather than saying, okay, we're going to use this, we won't use the PowerPoint.
Right.
We'll use exhibits that either have been admitted or
Okay.
that we tender through him.
Okay. All right. And so that'll be true for the rest of us.
Yes.
Okay.
So the whole PowerPoint's out.
Well,
Am I hearing that correctly?
we won't use the PowerPoint.
Yes, she's just saying it's going to be easier not to, because I mean, I would imagine he's probably kind of like press play and he's like, here's what happens in slide 1 and slide 2. And if he's not doing that, then it might be easier to do it another way.
Right.
Okay. All right. So then I guess as for the rest of it, we can keep going through with regard to the pictures themselves, or you can just, if there's some that, if there are some pictures depicted within the slides that the defense thinks are particularly egregious or objectionable that you want to go ahead and alert me to, that's fine. Otherwise, I guess we'll just see what happens at trial.
Your Honor,
Yeah.
wouldn't the same rule that your court said the state now will give us what they believe they're going to introduce as an exhibit through Detective Dennis, and we could raise it with you?
Yeah, that would be helpful. I mean, you're going to want to take a look at this and then decide what you actually want to use. So once you kind of narrow that down, if you'll just let the defense know which ones you actually want to use, then they can raise any kind of objections that we could get taken care of outside of the presence of the jury beforehand. That's fine.
So
Thank you.
Can I just make an observation
Sure.
or an objection? So before this honorable court took over, there were lots of objections as to, it was Detective Dennis allowing to say his investigation. So not a witness came in, the crime lab person didn't come in, just he was allowed to say, I learned of, and these CAD reports, I objected to everything on confrontation clause and hearsay. And the former judge denied it. So it all came in. I think the state, is about to do the same thing with the same witness. And I will be objecting again. And I also have this section. I'm looking for Georgia cases.
Okay.
It says, this is, I have a couple cases. This is United States versus Nguyen, Nguyen, F, that's wrong. 504 F 3rd, 561, 5th Circuit, 2007. Thus, while summary witnesses, which is what I call Detective Dennis, may be appropriate in complex cases in certain circumstances, they are improper for introducing evidence that the jury has not previously heard. We repeat our admonition that the government may not use summary witnesses for inappropriate means. While such witnesses may be appropriate for summarizing voluminous records, as contemplated by Rule 1006, rebuttal testimony by an advocate summarizing and organizing the case for the jury constitutes a very different phenomenon, not justified by the federal rules of evidence or our precedent. So to me, this is what I call a summation or a closing argument. And I know that the court struck it. So I don't have the same exact situation as my motion to exclude this, but this whole thing is a closing argument. This is PowerPoint was a closing argument. I understand it's no longer like that. It's dismantled and now we're going exhibit by exhibit and rulings. But my point to the court is if you can just, I'm not asking for an advisory opinion, but this is going to be, there's 2 Detective Belknap, 1 Detective Gaither, maybe 2, but 1 Detective Gaither, I remember, 1 Detective Dennis. They've all been over objection, qualified as experts. They're on the exact same situation. And now we're going to replow. Detective Dennis already testified as to the alleged back and forth. He already said all this.
Okay.
So did Detective Gaither. It's all over objection. But I would object that it comes in now again.
All right. And what would be, what's he going to be talking about new? Why are y'all presenting him again?
So because he's sitting through some of these, specifically some of the interviews that we were talking about, some of the actual shootings that we're showing the evidence of, like on April the 28th, the Hill Street shooting, he touched on them. We did not get into, like, he as an expert talked about what their investigation led them to do and sort of what their investigation entailed. He didn't talk about the details. We won't be getting into rehashing something he's already talked about. The stuff that he's going to deal with now is going to deal with specifically the interviews that he conducted depending on what the witnesses say. If there are some instances where, you know, we don't need to play the interview because they say exactly what they said, then we won't do that. But we're at a different part. He is a fact witness, and he's still he has still been qualified as an expert by the court. So we won't be rehashing stuff that he's done, and we won't be using, I'm not certain when Mr. Steele says, you know, he objects to summaries. As experts, they're allowed to talk about how they arrive at certain conclusions.
Yeah, I think there were maybe like a couple of different objections in there, but it sounds like one of the objections or potential objections would be if he's going to get up and basically rehash the same thing he already testified to about how, you know, the theory is that all of this came about because it was the culmination of, you know, some gang wars, basically.
We've already
That's already been covered, so he should not be testifying to that again.
Right. We don't need to, but specific, like the April 28th shooting, the Hill, like we haven't put up all the evidence in some of
Okay.
them.
Nobody in here is being charged with that shooting, right? That's part of the story of some of the crimes that are charged in the indictment, right?
I think the court is saying that they are overacts. Some of them are overacts that are listed in the indictment. If that's what the court is saying, the answer is yes.
Okay. So I may be thinking of the Hill Street shooting as something other than what it really
The
is.
Hill Street is not. The Hill Street is not.
Right. That's when Woody and his girlfriend get shot at, right? Or no? Okay. All right. Sorry. There are a lot of shootings that I haven't been in this case the whole time. So, all right. So, but I guess, so let's take, for example, that one. I mean, we're not going to need to get into the nitty gritty of that one because that one, all that we need all for the jury to know for that is it happened. Some people believed it was a rival gang. It, you know, made the beef worse. We don't need all the details about how many bullets were found, right?
That was free to read. That was Lucci's mom. And so
well, that was another one. But
so the overacts connect that shooting with the ballistics from that shooting.
Okay, so for that reason, that might be relevant. But,
and Lucci's a central sort of
right
opposition figure in the whole.
Well, I guess I'll just have to take them as they come, but we do not need a whole entire like crime lab. Here is, you know, what you would put in if you were the state prosecuting that shooting when that is not an overt act and it is just something that happened along the way that's part of the story. I don't want us to be having a mini trial about that.
And we've scaled back everything in the indictment, even like we were saying yesterday with the Rodelius Ryan murder. We've scaled everything down like that. So it's not to.
So are there other objections encompassed within what you just said, Mr. Steele, that I need to be addressing?
I don't see why Detective Dennis, through his investigation, is allowed to say, oh, there was a Hill Street shooting and this was gang related, or this was done by this gang in retaliation of this. And we linked up later through the GBI crime lab, a weapon that was used in this shooting and another shooting. You know, to me, that's all confrontation clause. And the investigation doesn't matter. They could have done the greatest investigation. What matters is that the state put up competent evidence before this jury to determine the charges and the elements in the indictment. So to me, it doesn't matter what their investigation was. Now, I have challenged the investigation that they did not verify or corroborate. I have no problem with that, saying, well, I did verify and bringing in the witness or who the witness was that they spoke with. Maybe not what they said, but what happened last time with the predecessor judge was over objection. Detective Dennis and Detective Gaither was able to say, oh, we verified that this happened in relation to this, and this happened because of this, and this started a chain with this. And this whole thing started in the fall, by September 2014. There were no witnesses here.
Okay, well, I mean, that's the subject for cross-examination then.
hard to cross when I have no reports. I have no reports. I have no expert report. I don't know who to interview to say, no, that's not true. I never told them that. In fact, I told them something different. This is all to me like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And I've asked for reports. Judge Glanville told the state to reduce it to writing. This is all confrontation clause and it's all coming in as a conduit through some quote expert. And it comes through with many experts. And to me, it's just like not having a trial.
Okay, well, I'm sure you'll be able to undertake an effective cross-examination of this and every other expert witness. I have been told since I've been in the case in front of y'all in court that there aren't expert reports. Does that continue? And y'all were going to circle back and ask whomever over at APD to do an exhaustive search, even if people were retired. What happened from that? Has that been
For
conducted?
police reports, yes, we were, actually, I think the court told us to do it for a specific act, and I can't recall which one it was, and we did, and there wasn't. But we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
Okay, you recall that I did tell y'all to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right?
Yes.
Y'all did that?
yes,
And that
you
produced
did.
nothing?
No, we
Okay.
nothing that we haven't turned over,
All
because
right.
what we did, what the court required us to do was, it was for a specific one.
I don't think it was.
Hold,
I mean, it may have been for a specific one and then everything else, but anyway, if it wasn't done for everything else, do it for everything else right now.
Your Honor, could we take a very brief restroom recess?
We just had one less than an hour ago. So, no,
I'm
sorry.
Okay, I apologize. Mr. Atkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes,
Yes.
we don't have anything extra. We will go back again, because I've gone over and asked homicide. I've asked gang. I've physically gone over to the gang unit, physically pull out boxes of stuff. I will continue to inquire.
All right. Well, I don't know that, the best use of your time is to pull in boxes and look through them. That ought to be what the police are doing, but you need to direct them to do that.
Yeah.
And so with regard to the gang experts, did y'all go back and say to somebody over at APD and in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I know, but then I ordered you to, so did you do it again?
Okay, so
Because I ordered you to.
we have not inquired a second time, and I apologize to the court.
That
We're gonna
is-
do it again. I will do it.
I pretty
personally.
clearly told you to do it again.
That's what he's reminding me.
Yeah, well,
So-
Mr. Atkins, you could have done it.
Well-
Yes, Your Honor. I'll go make a phone call now.
Okay.
And can I mention something? It came out during trial, during a motions hearing, that there is what I'm going to call a black book. And it's all the gang information.
Yeah.
Okay, you seem like you know about it.
I've
Well,
heard about this before.
okay, well,
Yeah.
I don't know about it. And we were told, we were given the Heisman. We were told that we're not getting that. Detective Dennis said he no longer works at APD, so he has no access. Detective Gaither said the same. Detective Belknap, who continues work there, says that's not for public information.
Well, I would imagine it is not. However, if such a thing exists, do y'all know what Mr. Steele's referencing?
If he's talking about what Detective Dennis said that he used in the beginning of his career as a law enforcement officer, where he collected information, I think maybe he called that maybe a black book. I don't know if he's talking about that or if he's talking about the information that they keep on gang members. I'll let him clarify, but.
All right. Do you know, Mr. Steele?
I'll take anything that has to do in any way with the testimony in this trial to either be able to go and interview the witnesses, confirm the witnesses. There was a lot of talk over objection. The policy of APD, how they qualify somebody as a gang member, it's self-admission, it's somebody else who's reliable, which say that they're in a gang,
Okay.
they hang out with somebody. All that's in this supposed book. I don't.
Okay, that's entirely different. And
Okay,
Judge-
so you now do know what he's talking about.
No, that's entirely different. Detective Dennis talked about, and Detective Belknap talked
Mhm.
about how they identify gang members
Okay.
and what criteria they use.
All
It
right,
is
is
not
that
true
something that is in
something in a
writing?
black book.
Well, whatever. Is it something in writing?
I think that the criteria, those criteria that they use, that is something that is a written sort of criteria.
Okay.
And I'll
All
get
right,
that.
let me propose, if that's easy to get and they don't have kind of security concerns with it being provided to the defense, then provided, if they do have security concerns, then it can be satisfied by saying, Mr. Steele and anybody else on the defense team, you can come look at this written policy, at 12 p.m. on XYZ day over at APD. That satisfies it also. So in some way or another, if there is a
Yo, those are nice. Hold on one second.
Candace, what's up? I think my
Of who they spoke with. They're talking about.
all right, well, they may or may not have anything like that in writing.
Well,
And
if
you
we-
can always just interview the detectives
Well,
to ask them those things.
well, I have interviewed the
Okay.
detectives, and they tell me that they're not releasing that information. They would speak with somebody. They'd speak with Brian Steele. Brian Steele would say that Keith Adams is not involved in criminal street gang activity. That would go into some sort of book. And they would speak with Carlton Matthews, and he would say that Brian Steele is in a criminal street, and that would go in some sort of book. I'd like to see that because they're speaking about, we corroborated this. So I asked on cross, who did you speak with? I'm not going to tell you. Well, why don't I have the right to know?
I don't know, maybe they consider them confidential informants.
He never said,
have to
I'm
get-
not, I don't think he ever said, I'm not going to tell you, Judge. I think
All
that
right,
what.
I'm not going to relitigate it. If it comes up again, we'll deal with it then. Okay. So I'm not even sure how we got on that. Oh, but Mr. Steele, you've said a couple of different times that you object to certain portions of CAD reports as being hearsay, and you were going to give me some law about that. And I don't know if other CAD reports are going to come in or not, but. Okay, well, provide it, and that way I'll. And provide it to the state as well, because if it's clear law, then they can just redact those portions of CAD reports, which might need to come out as hearsay. Okay,
So I have KAMUSOKO versus state.
I'm sorry, start over. I
Okay.
just didn't get that at all. KA,
KAMUSOKO
okay,
versus state 362 Georgia Appeal 276 footnote 3
and what does it say?
868 Southeast 2D 252 2022. Says Camusoko makes no distinction between any particular statements and declarations, and therefore has abandoned any challenges he may have regarding particular statements or declarations. There is nothing for this court to review where the appellant has failed to identify precisely what statements he challenged. In addition, although Camusoko mentions in passing that whatever was said to the 911 operators was filtered through people who did not testify at trial, he fails to include either citation to authority or meaningful legal argument that the CAD reports were inadmissible because the 911 operators or other persons writing down the declarant statements did not testify at trial. He therefore has abandoned appellate review of any challenge to the CAD report on this ground as well, and that ground is hearsay and confrontation clause. It's in Division 2 of that opinion, but I read
Okay.
from footnote 3.
All right,
So
so, I mean, that doesn't establish that if objected to, it would have been an objection with merit. It's just saying, hey, you're raising it on appeal, you didn't raise it below, we're not gonna deal with it.
But it's not, right, but the
So,
CAD report
okay,
could be.
maybe you could come up with one that instead of saying this is a potential issue, says, all right, here is the issue, and in addressing it, here's the law on that. Can you try to do that? Thank you. All right. Okay,
In this case, in Division 2A,
all right,
where the footnote 3 is,
okay.
and what the court said was it's admissible under an excited utterance of hearsay. It's
Yeah.
hearsay with an exception.
Right,
So
Okay.
my point is, some CAD reports they don't identify an emergency situation. So they're identifying a past event. So that would be a confrontation.
okay, well then, you'll just,
It depends
if you
on the
plan
CAD.
to make that objection to every CAD report, then give me the CAD reports
Right.
and I will make a ruling.
That's right.
All right, let's do that. So that can be on the agenda for tomorrow. Okay, thank you for clarifying that. I do realize that there might be times. I just thought y'all had some kind of blanket, this part of a CAD report is always out. And that is not what we have.
Right, it's like a
Okay.
911 call. It just
Yeah,
depends
no,
on-
I'm clear now with what you're saying. All right, so we've done the PowerPoint. So I am going to give us another quick break, but I'm gonna say, and I'm gonna say this once, and I don't want to have to say it again. And this is kind of what you say to little kids when you're on a road trip with them, is if we're taking a bathroom break, even if you don't have to go right then, if you could hold it for another 40 minutes, just take the opportunity to use the restroom so that we don't then 30 minutes into court again, have to take a break because now you can't hold it anymore. Okay? All right. So we'll have a little recess. I think we can move on to another task on our task list. Open to suggestions, or I'll pick one. I know we still have to do the excerpts from the wiretap evidence, so that might be a good thing to turn to next. Yeah.
I meant to bring this up yesterday. We've been labeling the excerpts from the wiretap as potentially co-conspirator statements.
Right.
And I think the state announced that those wouldn't be coming in until investigator Viverito testified. What I meant to inquire about the other day was, I know that they've suggested that there are additional co-conspirator statements. I'm just wondering if any of those are linked with witnesses coming up soon.
Hang on just a second. Nobody say anything because our court reporter needs to plug in back up. Our court reporter's still rebooting, so thought you might have something that was not something we needed to take down. Okay.
Some research to do on our case tomorrow. So with Mr. Williams' permission and Mr. Adams' permission and the court's permission, I was going to do that at my office. And I will not be here tomorrow, if that's okay with the court. And Mr. Williams said that's okay with him. He could speak for himself, and Ms. Adams said that's okay with him.
All right, sounds good. Thank you. Okay, we're back up now. So I don't know if all of what Mr. Sharp said got on the record. Do you mind just reiterating it?
So, yes, I will. We put off, we suggested that the wiretap co-conspirator statements are going to come in through investigator Viverito, which would be later on in the trial. But I believe that the state has also stated that there are additional co-conspirator statements, or alleged co-conspirator statements, that are not part of the wiretap. And I was just suggesting if those involve witnesses that are coming up sooner, that might be something that we need to address.
Okay. Do we have other co-conspirator statements that are not the ones from the wiretaps coming in through to investigator Viverito?
So, since we won't be getting to the wiretaps until she's number 91, witness 91, in terms of, okay. My question to the court is, would the court allow us to go in order of the witnesses that are coming up and deal with the buckets of.
Yeah,
exhibits.
that's fine. And I think that's kind of what the defense might be trying to figure out is, do we have some co-conspirator statements that are going to be coming up soon? And I'm fine if it's easier to just say, okay, we're talking about.
Lee's new spicy wings. 6, 12, or 20 delicious reasons together.
The next, Jamari Holmes is the next time that we'll have co-conspirator.
Can y'all all hear
statements.
her?
I'm sorry, I'll get closer to the mic.
Okay.
Jamari Holmes's murder is the next time that we'll have that issue. And that's the one that we were discussing at the beginning of court with Your Honor and
Okay.
Mr. Williams and Ms. Sabasi.
Okay.
So the co-conspirator,
That's a little ways away.
yes.
Does that answer your question?
I'm fine with that answer. As long as nothing sprung on us at the last second with these witnesses coming up, I'm fine with that answer.
Okay, so they do have what those co-conspirator statements are, right? They just, we don't need to litigate it right now.
I'm sorry, I missed what the court.
Do they have whatever the co-conspirator statements are, whether they're from the wiretap or a different source? Do they have them all?
Yes.
And have they been identified as potential co-conspirator statements?
Yes, Your
Okay.
Honor, for the most part. Just 1 second, I'm going to confirm one thing.
Okay.
Sprinkles folder have potential co-conspirator statements in them. We don't have them extracted out. We just have the ones in there
Okay.
that we intend to use.
All right. I mean, y'all ought to be aware that if there are jail calls by co-defendants, that those might contain co-conspirator statements. So that would be the only thing that might not be specifically identified. Is that okay?
My expectations are correct in line with the courts. The state is going to specifically identify those alleged co-conspirator statements. Correct. I mean, there's thousands of jail calls from probably, I'm underestimating, well, thousands, yes. So we would need to know what statements, when they're made, between whom and whom, if the state, because we would like to litigate these beforehand. I know the court would too.
We put in the Mike Sprinkle bucket, the jail calls that we're using.
All right. So jail calls y'all intend to use are all in the Mike Sprinkle folder.
The ones that we, yes, the ones that we have identified that we intend to use, and those are the ones the court told us to.
Okay, so the universe has been narrowed, hopefully substantially. I haven't looked to see how big the Mike Sprinkle folder is, but
If it's the same one that I think they're talking about, it's about 200 calls,
okay, well, then,
15 minutes each. So that's 50 hours of,
okay. Which I presume is one of the reasons y'all said, let's hold off on dealing with what's in the Mike Sprinkle folders. So as the state, look here, as the state is itself going through the Mike Sprinkle bucket in further detail and identifies for itself the specific co-conspirator statements that it intends to introduce, please identify those as well to the defense. As soon as you know, let them know.
So we have 14 in the Shannon Stillwell folder. We could start there since that is his client, Mr. Shart's client, that we could actually review.
Okay. Let me get some clarity. So in the Stillwell file of jail calls, are those already identified? Just here are the co-conspirator statements, or are they just like, here's a 15-minute call, here's a 5-minute call? All right, and do you know what portions of those calls you? Yeah. All right, but whether you've broken them out or not, do you know what those are? Okay, so if you can, if that's what I'm saying, is once you know, here's call from January 2nd, that is 15 minutes. I'm going to use minute 2.5 to 2.9. That's the part I care about. When you know that, let the defense know that. Okay, so if you know that already, instead of us sorting it out here live, give that one of y'all sit there and type it up and send it over. They can look at it tonight. We can deal with it tomorrow. Okay. And similarly, do that for everything else. All right. So that it sounds like the most productive thing to move to next, unless somebody else has a different idea, I'm willing to listen, is to just open back up, you know, the witness folders and move on to whomever the next witness other than Mike Sprinkle is going to be, and go through that proposed evidence for any kind of evidentiary issues we can hash out now. All right, let's do that. Dropbox link we were working from yesterday, that is the Dropbox link of the first 30 witnesses. So if everybody can find that again. Bless you. It's not easy to find it because sometimes instead of y'all giving each a new reline to your email, you just tag on to one that already existed.
8th, 2024 email from Mr. Atkins.
I'm pretty sure. That's right, right?
Yes, Your Honor. It says 30 witnesses and then it has 8 August 24 in parentheses.
All right, y'all let me know when everybody's there. Is everybody there now? Almost. All right. I'm waiting on y'all to tell me if you're there. All right, is everybody there? Has everybody got the 1 through 30 Dropbox link up?
We have the full, Kendrick has the folder. We have-
Okay,
I don't know about it.
great, thank you. All right, I've heard from 2 of the 6. Y'all ready? Okay, 3. Stay ready. Okay. Mr. Matthews, you got it? All right. Who else? Are you ready, Mr. Sharp? Okay. Mr. Adams or Mr. Steele? Okay. All right. All right. Here's the one we're waiting on. Okay. You will catch you. Okay. All right. I think that we yesterday had gotten, other than Mr. Sprinkle, through. There was nothing with regard to any of the phone custodians, right? Sure. Sure. All right, so the question on the floor was whether there's anything we need to look at with regard to any of those three cell company custodians.
As to those records, we can just bring in the records themselves and save that time, but
That would be nice. How about it? Miss Westmoreland doesn't want to. Okay, no, that's not gonna happen. All right, well, so we'll have three more witnesses, but with regard to the evidence within those, any kind of motion and limine type issues we need to deal with on those? Thank you. Okay, then James Burney is the next witness listed. Do we need to look at anything with him?
Expert from the FBI phone records.
Okay,
And this is one that I voiced an objection to repeating the testimony because Agent Racy talked about for a long time where the phones were located. The prosecution stated that based upon questions by some of the lawyers for the accused, that they needed to do something else. I'm still holding my objection because I believe it's going to be, I looked at the report, it's the same thing, maybe a little nicer because it was done nicer. And I don't mean to insult Detective Racy. He didn't have like a chart, but I just believe that it's the same. And by when the same, I'm talking about the April 26, 2015 shooting of the tour bus of Mr. Carter, a performer known as Lil Wayne. Otherwise, no, I don't have any issues with with
Okay.
Agent Burney.
all right.
And Your Honor,
Yeah.
per the court's guidance, this April 26, 2015, we are not discussing the Special Agent Burney. This, when he speaks on specifically the January 10, 2015 murder of Donovan Thomas, that's the only cell records he's going to be testifying to right now. He does analyzes cell site tower data for other acts in this case and counts. So he's one of those witnesses that testifies multiple times when that act comes up. So what Mr. Steele, specifically the April 26, 2015, we will not be
Calling him for that purpose.
correct, Your Honor.
Okay, but so when he's called here, it'll just be for the January 10th,
2015. Yes, Your Honor.
2015. Okay, anybody else? Nope. I hear, all right, not hearing, but I'm seeing nods, no. Okay, all right, great. We'll move on to the next witness folder. All right, GBI Firearms Boss in Wheatsoul or Whitesell. Any issues on those?
My understanding is that these witnesses listed are the witnesses that are going to be called. Is that correct?
Mr. Voss is not going to be called pursuant to the information we sent to you all a few weeks, 2 weeks ago, maybe. Mr. Weitzel is going to be called. I believe there's on the email that we sent to the court and to counsel for the defense, the peer reviewer and the verifier for David Voss would be called rather than Mr. Voss.
All right, and is that peer reviewer / verifier Weitzel?
No, it's actually Vanna Kelly.
Vanna Kelly? Okay.
Yes.
is that Ms. Kelly?
Yes.
Okay. Does she have her own reports?
Actually, what we're doing is getting the data, the underlying data. So she verified these. And so any underlying data that she has that they may want, just in case they want it, we have to get that for them.
Okay.
It's unclear to me the work that I guess Miss Kelly did on this case. It's unclear to me what the work she did was, but obviously, Your Honor, there's potential for confrontation clause issues involving Miss Kelly testifying to the results.
All right. I would presume, I mean, typically when they testify, they say, I ran all the tests myself.
Right.
And obviously, if they didn't, then that's going to be problematic.
Right, it would be. She looked at the evidence under the microscope herself and came to the same
All right.
conclusion.
So she will be testifying to her own conclusions, not to his
No,
conclusions.
Right, hers match his, and he was the one that put out the report. She verified his by going through and looking at that physical evidence under the microscope.
Okay, but her conclusions will be based upon her own
Correct.
testing and observations.
And to my understanding, we don't have a report from Miss Kelly. If maybe she's not writing a report, I don't know, but I'm bringing it to the court's attention, the state's attention, that my understanding is we don't have a report from Miss Kelly. So if one was generated, we need that report.
That's what I was just saying. She did not generate a report, but her underlying notes and data, that is what we said we would get for them, because her conclusions.
She doesn't have a separate report, but she's got notes and data, and y'all will be provided that when? Did y'all have that yet from her?
No, I spoke with the GBI last week, and I'll follow up this week.
Okay. Let them know that this is an ongoing trial and they need to
I will.
provide it ASAP and then provide that over ASAP to the defense. Okay.
Also, with respect to Agent Bernie, if we could swing back to that.
Sure.
He will likely not be testifying until the end of September, in which case any time needed, we believe, for the defense to review his analysis of the April 26th incident would have, we believe that rather than having him testify 2 different dates for those, for the incident here and the incident in April, would be obviated by the fact that he's gonna not be testifying until the end of September, as opposed to having him testify at the end of September and then come back 2 weeks into October. So I guess we're asking for clarification on whether or not he can just be brought in, whether that is not enough time for them to look at the additional reports that they were given last week, or was it last week? Week before? Week before last, right?
Okay, let's find out.
The issue isn't the amount of time that we had to review Agent Bernie's report about the April 28th incident. The issue is that Detective Racy already testified concerning the movements of cell phones. And and the state seems to be justifying this on some sort of cross-examination. Really, the allegation is that Mr. Winfrey was moving with the bus, and the allegation, which I strenuously deny, is that Mr. Stillwell was moving with the bus. Mr. Stillwell didn't have a cell phone, so I'm not sure what the point of any of this is in the first place, much less hearing it for a second time.
Okay.
Yes, Your Honor. During cross-examination, they challenged Detective Racy that he was not an expert, and therefore that he could not testify as to what side of the tower that the phone was on, only the tower placement.
Okay.
And because it was specific as to what side of the tower it was on, that's why we asked Agent Bernie to do the analysis based on their cross-examination. I think specifically Mr. Weinstein objected that because Racy was not an expert, he could not testify to what side of the tower that the phone was actually on, which is important, given the movements of where the phones were at particular times, the evening or the morning of April 26th. So that's why it became relevant for us to get Agent Burney to do the analysis, because he can talk specifically about what side of the towers the phone was on at a particular time.
All right, which phone?
This was, it was Mr. Winfrey's phone, also the phone that we're identifying as Dolly White or Max's phone. There may be about 3 or 4 other phones that I can't just recall off of the top of my head, but all these individuals were ascended upon the compound, which is where they started, and followed the bus all the way up to the hotel.
Okay.
And then went down to the studio after.
Okay. And does anybody identify a phone as one belonging to any of these co-defendants?
Not.
I can't get this to go back to. Hang on.
Oh, sorry.
All right, go ahead.
Only phone that he analyzed from these defendants here will be Mr. Williams' phone, because Mr. Williams' phone, we had that plotted that he was in Baton Rouge at the time of this, which was consistent with what some of the testimony.
Okay, so tell me why we need to hear from and we may, but tell me why we need to hear from Mr. Burney about the side of the tower that other people not on trial hear.
Because it's a part of the conspiracy, and it corroborates what other people said about the movement and where everyone was at the time. And because they challenged it so much that we can only say that this is where the tower was, but with no more information.
Okay, and was there testimony, whether there were cell phones for these people or not, was there testimony that X, Y, or Z co-defendant on trial now was with this crowd?
We believe that some testimony will come in soon, that Shannon Stillwell, although we did not have his cell phone,
Right.
that Shannon Stillwell was present at the time of the, but it has not come in yet.
Okay, all right. So then, with regard to that incident, Mr. Burney's testimony should be on the narrow issue of, I analyzed these cell phones and I can say that it was this side of the cell tower. But we won't need, I would think, to go through, I don't know, but did Detective Gracie give sort of the overview of here's how we know all of this anyway, and here's what,
Correct.
Okay,
Yes.
so we won't have to go through all of that again. You can just cut to the chase of, yeah, I know all of that stuff too, and here's what else I know.
Yes.
Okay,
Yes.
that works. All right, so moving back to,
Can I ask you a question?
yeah,
Does that exclude then Mr. Williams, who's in another state at the time? We're not going to hear about that again.
I mean,
Am I correct?
are y'all gonna bring that up again?
Because that
Yes,
was testified
but
to.
in the sense that he received that document and he plotted that as well. Yes, but we don't have to go into the details of it. But I think it's it's part and parcel of what was happening that night
All right, hang
that
on.
they challenged.
Hang on. Did anybody from the defense challenge the legitimacy of Detective Gracie's conclusion that Mr. Williams' cell phone was in a whole other state?
I agreed with it.
Okay, then if there was no challenge to that, that should need to come up again. Right?
Can we ask him whether or not he plotted that phone? Because if he's going to talk about some of the records, we think it important that at least the jurors know he didn't. He
Yeah, I
didn't
mean,
come with the same.
yeah, if it's like that could be like a one question.
Yes.
Yes, and it was in somewhere else entirely, which I would think, Mr. Steele, at least you would like. Okay. Well, that part certainly wouldn't. So you, okay. All right. That is what I said. Okay, so back to the two firearms examiners who are going to be Kelly and Weitzel, where we can move on from that. Silence is yes here. Okay, so next is Officer Zaffa. Looks like, is this one of the crime scene techs?
He's the responding officer to the January 22nd, 2015 shooting at 1007 Hill Street that we talked about
Okay.
earlier.
Any issues with this?
And you're right.
Mm-hmm.
I think it's actually Officer Z Atha.
Oh,
Yes.
okay,
And
there's no
I
space
changed it,
between
yeah,
those two.
and
Officer Alpha. Okay, thanks. Any issues on those photos, images? Are y'all just looking at these now? Okay.
My concern is I don't have any statements from any witnesses, have the officer responding, but we'll see the next witness that you have on your list. We'll see if there's any more information that we're supposed to get.
we had the police report, Your Honor, that we provided, and then we provided, at least for this one incident, will be Miss Reed, which is the victim in the case, and so that is what we intend on introducing.
And is there a statement of the alleged victim? That's what I was.
Her statements are reflected in the report to the extent that she gave on site.
I doubt if they can hear her, that y'all just gonna have to pull that mic back over.
Her statements are reflected and memorialized in the reports that were written and provided to the defense.
Okay.
Just so we're clear, my understanding is that the allegation is her home was shot up multiple times. And so we do not have any written statement or any taped statement by any detective, taken by any detective, given by this alleged victim. And so that's what we're asking about. We understand that statements may be memorialized in a report, but we are specifically asking about taped statements, written statements.
Your Honor, we'll double check, but the answer be no. Whatever her statements is contained with what she told the responding officer and he put in his report.
Okay. And this was way back before body cam was
Yes.
typical, so
Exactly.
that wouldn't be unusual. All right. If y'all find something else, obviously provide it, but no, that to their best belief at this point, no, there's not anything. You have everything that there is. Okay, so I'm assuming that other than that concern, there aren't any issues with these pictures that are included, since I hadn't heard any objections directed to those. Is that fair? Okay, thank you. All right, next is Sanders. I'm not sure what CST stands for, but crime scene tech Sanders. Very good. Also lots of pictures and images of their walking through the crime scene and documenting it. And then the report. Any issues? All right, thank you. All right, moving on to Antrevia Smith. What is that, a video? Okay, any issue on that? Oops. It's a short video, so even if you're watching it for the first time now.
I was under the belief that they were going to introduce this video through Mr. Sledge, but
All right, hang on, and nobody can hear across the courtroom if we don't talk into the mics. I know it's annoying, but
We have it coming in through Mr. Sledge. That's why we were just pausing, because it's already been an exhibit that's identified
Okay.
as coming in through Mr. Sledge, but it was Ms. Smith who gave it to the police following the shooting of her apartment to show the antagonism that existed between Mr. Sledge and YSL and Mr. Watts, whom she was also seeing. So that's the reason that it's in both folders.
I would hope the questions are not articulated that way in trial, because it's Mr. Sledge arguing with another man over a girl. I don't know YSL how that fit in, but
I think.
okay, well, that may be, it probably will. And if it's presented that way, then y'all will have some good subject matter for your cross-examination.
That there's Mr. Sledge, since it was mentioned, Mr. Sledge said, oh, no, it wasn't over a girl. We
Okay,
weren't beefing over a girl.
all right, well, they'll say whatever they're gonna say, and y'all can examine accordingly. All right, Sharon Latner's. These would be the CAD reports, I assume. So we'll hold those for tomorrow. Does that work? Okay. And tomorrow, y'all can tell me what parts of, if any, of those y'all think might be excludable as hearsay without an exception. All right. We are moving now, at least theoretically, to a different overt act, I think, right? So now we've got crime scene tech Turner. And that folder is empty, at least for me. Do y'all have something in y'all's folders for that? They're empty for y'all too? Okay, well, maybe that was just a mistake. Is there supposed to be something in that folder?
I'm gonna check. I think that we may have already.
All right, we'll come back to that one. Y'all check on that tonight.
And that may have been the ones that they told us that APD no longer existed. It may have been the ones that we identified and told the defense about. There were about 127.
From the hack from whenever
Yes,
that was?
we had asked them for the physical copies, if there were any, because they said that the digital copies did not exist.
Okay.
And so that, I think that those were, it was Turner. It was Turner's
Okay.
photos that were those photos that we were trying to
Those
get.
were lost in that several year ago hack, it sounds like. So that's why
what-
that's empty.
That's what the photo lab
Okay.
told us.
All right, moving to Jenkins. And these are just crime scene photos. Look pretty standard. Any objection on those that y'all anticipate? Okay. All right, Tyrone Dennis. All right, let's walk through it kind of one by one. All right, so the first thing is what's identified as States Exhibit 71, Act 78, and then the lyrics to Bad Boy. All right, what's our objection? And this is only if this hadn't already been litigated. If it has, it has.
Mr. Williams doesn't, these are not his writings.
Okay,
Somebody, Google, I was told Google, just put them down. I'm not telling you that they're wrong, but I'm certainly not telling you they're right. But it shouldn't come in this form. This is not how Mr. Williams made a song.
okay.
So I would be objecting to the best evidence rule. And I don't know why, I don't know if the state is planning to hand it out as an exhibit to the jurors, flash it on a screen, but I don't believe that this is proper testimony. In addition to that, Detective Dennis, for him to claim here are lyrics and here's what they mean, I don't think he has any basis. I've asked him whether he,
Okay,
when he was qualified, whether he spoke with anybody with the lyrics, how he makes the lyrics. He has no idea. He's just a listener.
okay.
So those are all but those are, I raised those objections previously when we
Alright.
were arguing.
And, sorry, go ahead, and what?
And the court stated he made a preliminary finding, the prior court, that lyrics are admissions, confessions, co-conspirator statements, and if a proper foundation is laid, and he will decide later if they come into evidence. That's
Okay.
pretty much how
Thank
it
you.
was.
All right, so the best evidence objection y'all might need to deal with.
Your Honor, we would be, as far as the displaying or the publishing of the song and the lyrics to the jury, we would likely be doing it through Mr. Williams' words as he speaks them, and we may have a accompanying, it can be typewritten, whatever, transcript of the lyrics, however it is that we intend to display it, but that we can also provide to the jury in terms of their ability to more easily hear
As a
what is being said.
demonstrative aid.
Yes, and as far as the objection as to the meaning behind certain words or lyrics, Detective Dennis would be talking based on his expertise in certain areas, particularly as a gang expert,
Mhm.
as to certain meanings or certain language. But if there isn't, if there's a different interpretation or if someone else intends it a different way, then we would submit as the area for cross-examination or different testimony from the
Okay.
person who's saying.
All right, well, I think that with regard to something being used as a demonstrative aid, you need to make sure it is the correct transcription of what the lyrics actually are. It does not need to be pulled off of Google. I mean, if you want to pull it off of Google, you can, but it doesn't need to look like this. And please provide it to Mr. Steele and Mr. Adams beforehand so that if there are any disputes as to what the words actually are, those can be dealt with. And then I would permit Detective Dennis, if he's been qualified as a gang expert, to say, you know, in my expertise, this might mean XYZ. Obviously, it doesn't mean that is what it means, but that's his opinion of it, which the jury can accept or not accept. It's up to them. And of course, he can be crossed as to how on earth he might know that, and, you know, all sorts of good things, I imagine.
I guess it depends on the lyric, but you know, intention can never be discussed by an expert, a person's intention, because it's
Sure.
not beyond the
Agreed.
candidate jury.
I mean, yeah, I wouldn't let him say, here's what Mr. Williams meant when he wrote this lyric. Just this lyric in common gang parlance, we believe means whatever. Okay. All right. All right, the next is Exhibit 72. The same, is basically the same thing. This is just another set of lyrics. Okay.
Your Honor, one other thing when we're talking about these lyrics that I think I need to bring up right now.
Okay.
I believe that, well, we are going to be asking for a limiting instruction.
Okay.
I don't know how the performance of music, I mean, the state is fighting us tooth and nail saying YSL is not music.
Mhm.
So I don't know how that at the same time putting out music could be in furtherance of a conspiracy. So I would think that the lyrics can only be considered in regards to the person who is the source of the lyrics and not the other people sitting here.
Judge, I think that
Mhm.
so one, we've never made the contention that YSL members do not rap. We have repeatedly asserted
Yeah.
that there's that aspect of the gang.
Mhm.
So that's not true at all. And I believe that the issue of who it comes in against has already been litigated. I will make certain, looking at the order that Judge Glanville has entered, but there's no limitation as to this only comes in against Mr. Williams because he's the one that said it. It's not a testimonial statement. We would argue it's at the very least a co-conspirator statement, but and at times there are adoptive admissions, at times it's a party opponent, but there are various hearsay exceptions that allow these statements in. And Judge Glanville, we're looking up the order, but I believe Judge Glanville specifically ruled that they come in as co-conspirator statements. We'll look back at the order he wrote and entered after our very, very long hearing
Okay.
on this matter.
Okay, well, y'all about that. And if y'all want a limiting instruction, you can certainly propose one and I will take it under consideration. And, you know, if it's a blanket, every bit of this is a co-conspirator statement, that's one thing. If some of them are one exclusion and, one exception and some are another, I'll just have to look when I'm considering a potential limiting instruction.
And Judge, also, when we intend to enter certain statements made by certain of the defendants in that they have put a beat behind, we don't intend to play all of the words to all of these songs by any means. So we'll extract the words that we intend to introduce and are aware of those. And
Okay.
tailor those to the order that has been entered in any order that, rulings that the court makes.
Okay, thank you. All right, so our exhibits down through 79, also lyrics.
A lyric, 79 is
so-
a video.
Sorry, then 71 through 77 are all lyrics.
Yes.
Okay, so the ruling would be the same as to each of those. All right, so now we'll turn to 79, which I can't seem to open.
It's a picture, actually.
Okay,
I can share it, well,
okay, thank
want me to
you.
share it, Charlie?
Sure. Okay. Okay, it's already in.
I don't think the caption.
I couldn't hear you. What'd you say?
We believe that's in already. We agree.
Okay, Mr. Steele, did you say something about Bruton?
That's what I'm reading, but no, I said the same thing as Ms. Adams.
Okay.
I cannot be 100% sure, but I
But
believe
y'all, all
it's.
right, well, if several of you over there think it is, and y'all think it might be.
The
also-
caption may not be.
Okay, any issue with the caption?
Not 100% sure. I believe it's in, or at the very least, it's been testified to. But I guess when we find the original,
All right, y'all can let us know on that one then.
Judge, did we reserve on, or in some of the 71 through 77 because we were going to check the order? Judge Glanville's order, I want to reserve on 74.
Okay, yeah,
And-
we did. We're gonna
Okay,
get the order and then come back to that.
all right, thank you.
Thank you. Suddenly. Sorry, y'all. Somehow everything got closed, so I'm opening it back up. Okay, so then next would be Exhibit 82. Is that already in by chance?
I don't believe it's in. I believe we've discussed it in regards to another witness
Okay.
previously. I don't have any problem with it personally.
I believe we talked about this.
I
picture
think we've
yesterday.
already dealt with this. All right. States Exhibit 83, what is it, Lima LL? Not that up on my native phonetic alphabet. I got it right. Lima Lima. What is, I mean, I know what this is, but what does this have anything to do with?
Your Honor, that is I believe that is the gun, yes. That is the gun that was found at the Dunbar Center with Mr. Copeland.
All right,
And the
any
H&M
issue
bag.
on this?
Not if there's an appropriate testimony to it. So no, I don't anticipate any issue.
Okay. So I imagine, obviously, they'll have to establish that's what it was, but assuming that is established, that can come in. Bless you. Okay, and then 84 Lima Lima A. Any objection?
If this is this the black and white picture, Your Honor?
No, this is a video of a club.
So this is, Your Honor, September 30th, so the night preceding the October 1st overact with Mr. Kendrick and Mr. Arnold, where Mr. Arnold gets into a fight at Magic City. This is a video of that. And that's also 84, it's 84 LL, A and 84 LL.
Okay. Any issues? Evidentiary issues?
Not assuming they can lay the appropriate foundation.
Okay. So okay, LL is just a different view. Okay. So, and then there's another 84 LL
LL and then 84 LLA.
and
Both
then
of them
another
are-
84 LL. Maybe that's a still? I don't know.
Let me see.
Oh, no, that's a gun. Maybe
So, okay.
there's a mislabel.
There's a
maybe.
mislabel, Your Honor.
Okay. Okay, so whatever that gun is will need to be
A different label.
a different number, but I assume that's some gun that's some way tied to something.
Yes, that's the gun, Your Honor, that was found on Quindarius Zachary when he was at the gas station.
Alright.
That's it.
Okay,
Quindarius Zachary. Yes.
then we've got 85 through 90 LL. Any objection to any of those?
Is the interview of Mr. Kendrick.
Okay,
Yeah, and we've already dealt with
All
the
right.
PowerPoint, which is 86.
all right.
87 as well.
We've dealt with 87 already.
Yes. 'cause
Okay.
that's-
Oh, yeah, that's, okay.
we have not dealt with 88.
88. Any objection to 88? Yeah, evidentiary objection.
I'm sure we'll be objecting to the commentary on this posting.
Except for the ones by Mr. Stillwell, I suppose. Because so yeah, okay. We wouldn't have any problem taking out anything that Mr. Stillwell doesn't post.
Okay, yeah, I mean, that's gonna be done for all of these kind of Instagram-y type posts anyway, right?
Yes.
Okay. All right. Yeah,
If the state would educate me on the relevance of Mr. Stillwell's posting there.
Okay,
But they
so-
think it means, because I mean,
all right.
I'm not gleaning too much from it.
Okay, there's a relevance objection.
All right. So, Judge, we are alleging that Mr. Stillwell is a member of and a participant in a criminal street gang and a criminal enterprise known as YSL. His donning of these red bandanas, one on his right hand and one over his head, and his use of welcome to be that red bee with the red heart, Day Paradise, on March 28th, 2015, during the year or the relevant time of this back and forth that was going on, are all relevant to the allegations made in the indictment. So with relevance being
Your Honor, I
the bar that it
misspoke.
is.
Hang on, don't interrupt.
I'm withdrawing.
Oh,
Oh.
okay.
I misspoke. I thought they were saying that someone replied to Mr. Stillwell, and I thought
Okay,
they
no,
were
they're-
saying that was his
She's
post.
taken all that off.
Okay, all right, I'm good, thank you.
All right, thank you. I think that's 100%. Anyway, not a heart. Had to get my glasses out for that one, but
I could.
I think the argument would be the same. Okay, so that objection's withdrawn. Long as, yeah, you just need with all of these to take off the comments. Same with 89.
Yes.
Any issue otherwise to 89 LL or 90 LL. Well, 90 LL is not a photo, it's a video. Any objection to either of those?
Your Honor, as long as they keep my client's comment on that exhibit as well, where he
Good.
sarcastically says we beefing, mocking the idea that there's gang rivalries.
Are we talking about 90 LL?
We're talking about 89 LL, right?
Okay.
I don't actually see that.
He doesn't say what his client says dripping through Cali with some real ends at Gotti with that red B. His client is not listed under the 6 comments that are going to be taken out.
Is there like some comment later that isn't shown maybe? Because I don't see it on this.
You're right. I think he's talking about, correct me, the first comment says at SB with the we beefing, but I don't think that that's Mr. Stillwell. That's
Okay.
the other person posting that she's beefing with him.
What's going on is
Mhm.
these comments are in dark blue on the black background, so I'm
Right.
only seeing the white. So I'm seeing my client commenting, we beefing, which obviously would be sarcastic. He's sitting next to his friend, but now I see the blue that Okoye having her way posted that, so.
Yeah. Okay. All right, how about 90 LL?
We'd be objecting to 90. I don't see I don't know what the relevance is of
Okay.
90
All right, there's a relevance objection to 90 LL
and 403.
and 403.
Judge, I think it's best if we just play this
Okay.
one.
Big B, Lil B, Slime, YSL, Crip Killer.
That's Mr. Williams's voice.
Based on
Directing
Let's not interrupt each other, please.
directing this child to throw up these gang signs.
Okay.
So that's what we.
So are you going to have some kind of either somebody familiar with Mr. Williams' voice to say that's him or a voice analyst to say that's him?
We would have someone that we believe is familiar enough with his voice to say that that's him.
Okay, well, we'll see.
On behalf of Mr. Stillwell, we're going to ask for a limiting instruction. if that's admitted.
All right, provide, proposed one, please.
On behalf of Mr. Williams, Your Honor, what
Mhm.
is the import of this? So I understand it's prejudicial because a person may think that a young child using what I would consider gang language with their hand signs
Mhm.
may be inappropriate, but why would this matter here? The lyrics are coming in. Mr. Williams is constantly changing the letter B to, or letter C to a B. Like instead of Cleveland Avenue, Believeland Avenue, there's a whole bunch of lyrics that Judge Glanville let in. There are tattoos on Mr. Williams' body that has already come in that shows the letter B and alleged other supposed gang symbols. They have introduced, they being the court has admitted into evidence exhibits showing things like a green snake or an emoji with a B on it. I just don't understand why the child is an important part of this mission to find the truth here. And Mr. Williams' voice, I find it to be wholly prejudicial, and I find the probative value to be scant.
All right, let's hear from the state.
So, Your Honor, as the court is aware, the rules of evidence are rules that favor admissibility, and 403 should only be used in extreme situations. And Mr. Williams, not the state, bears the burden of showing when something is shown to be relevant, it's presumptively admissible, and he bears the burden of showing that its prejudicial effect substantially outweighs its probative value. And Mr. Williams has said nothing about the prejudicial effect of this video with his child, with Mr. Williams dictating to this child, throw up B, YSL, Crip Killer, which are all things that Mr. Williams has attempted to distance himself from throughout the entirety of this trial. He has asserted that all of this is, not real. All of this is, just a facade. And the more that the state is able to show to the jury that this is, in fact, not a facade or not someone hitting on Mr. Williams' designations that are not accurately pinned on him, then the stronger the state's case becomes. So our argument is that Mr. Williams has in no way shown that this video is substantially more prejudicial than probative.
All right.
Your Honor, with respect to Mr. Huey, we would also chime in on the 105 instruction, but notwithstanding that, Your Honor, can you hear me, Judge?
I can hear you. I don't think that's working, but I can hear you anyway.
Can you hear me now, Judge?
Yes.
So we would also ask for the 105 instruction on behalf of Mr. Huey, but notwithstanding that, Your Honor, this is extremely prejudicial from the standpoint of having a child hold up these gang signs and so forth and so on, what appears to be gang signs. And again, this is going to be one of those scant and cumulative aspects of a piece of evidence that if the court allows it to come in, it's going to be drug in for the sake of its prejudicial effect. Clearly what 403 says we can't do. So I would ask the court to take that into consideration.
Okay, well, I'm certainly considering the appropriate law. Yes, sir, Mr. Steele.
There's also another, I can't find the exhibit number, but there's a video that came in over objection that Mr. Williams is doing something similar, or someone's doing something similar with a child.
All right, why don't y'all get me that and I'll consider whether there might be a cumulative issue here. But with regard to just 401, 403, it's certainly relevant, and I agree that it's prejudicial, which, case after case says most of the state's evidence is prejudicial against defendants. I don't think it's substantially more prejudicial than probative, considering part of the conspiracy they allege is preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating alignment to the enterprise and a willingness to engage in violence on its behalf. I mean, it's wildly probative to that.
And Your Honor, we're also going to ask for a Rule 105 instruction on behalf of Mr. Kendrick. And
Okay. Well,
we
I-
echo the comments
ahead.
made by the others.
Okay. Yes, ma'am.
We don't believe that a 105 instruction on this type of evidence is appropriate. It's not a testimonial piece of evidence, a testimonial statement. So we would ask that a 105 instruction not be given in instances where this is the evidence being presented. And we would also submit that Jeffery Williams is alleged to be the leader of this gang, and in having or directing this child and other children to do things like he's doing, he is, in effect, he's starting early and starting young. That is part of the state's theory in this case,
Right.
that this gang recruits young children, and this is what it ends up being.
Judge, I think there was a piece of evidence that came in on, or we reviewed a child on yesterday, if I'm not mistaken, that we saw in an image. It was either posted.
Yeah, but I don't remember that being anything that the child was doing in response to somebody directing them to do it. I think it seemed like the child was, I mean, I'd be happy to look at it again, because that's not specifically what I was looking at it for then. But if that's what y'all are thinking about, you know.
Well, that's one at least that immediately came to my
Okay.
memory.
And do you recall that child was doing that in response to somebody directing them?
I'm not sure if there was sound associated with that
Yeah.
particular image, but it was certainly at the direction of an adult, and then the child
Was it Mr. Williams?
I believe it was.
Yes, Judge, it was. It was the one of the two videos that you saw on yesterday. And when you listen to the sound, it's exactly the same thing. The child is being directed. And in fact, it's the same child.
Okay,
He says big B, little b. He doesn't say Crip killer. He doesn't say YSL.
all right, that is not cumulative, if that's the only one that y'all had in mind. So that's, I'm overruling those objections. Okay. I think that takes care of that witnesses exhibits, at least for now. Martinez Arnold. I see there's a plea agreement in that one also. Same grounds as before. Is there anything in particular on that one? I know there was. This isn't the same one we talked about before, is it?
Mr. Slade.
Okay.
It will be similar ground. You know, he's testifying, so why do we need a plea agreement? And the state wants to put it in, my understanding. And it would be continuing witness because it's a statement, and he could testify to whatever, and then he can get impeached.
All right, well, continuing witness is only about whether something goes out to the jury or not.
Correct.
So that's not relevant to whether it actually comes in or not. And then it's the state's intention to use this only if you need to impeach him as to something? Okay.
Correct, Your Honor. And if he's truthful, then we don't need to accept, I mean, if he's truthful, then we don't need to go and show and introduce this as an exhibit. And I'm assuming they're talking about the factual acknowledgments, not the
I don't know.
not the conviction
I
itself.
don't know. Let's find out. Are we talking about the factual acknowledgements?
I am talking about the factual acknowledgement, and then there would have to be a proper purpose for the guilty plea, which there could be one, but I didn't hear it yet.
All right, is there anything about the factual acknowledgements here? Like, I know that last one y'all were saying, I don't think this person has any firsthand knowledge. Is there anything like that I need to look at in particular? Okay. All right. And so for these people, you just intend to have them admit they pled guilty? Okay, so this wouldn't be relevant at all unless they say, no, I didn't, or no, I never
Right,
asserted
like-
that fact, or
so-
this would be,
So right, or that he was forced, or he didn't
Right.
know what he was doing.
right.
I think the certified conviction might actually be proper evidence. I need to think about that, but as far as the other stuff that they're
I
talking
mean,
about,
yeah, and you can certainly, I guess, tender that if you want to.
yeah. But
know what I mean?
the other information is only, as we said earlier, if someone isn't truthful on the stand.
Right, okay. Thank you. All right, the next item in there, I can't open, so I don't know what that is, but if y'all can open it and you know what it is and don't have an objection, then it doesn't matter that I can't open it.
Your Honor, we're talking about the third one down?
I was talking about the second one down because I don't know what that is. The one labeled like NT Fulton CODA and then some numbers. Oh, okay. Don't know why I can't open it, but we've already reviewed that one. Or no?
So this is a transcript of an interview with Mr. Arnold, and there is no need to enter this or use it unless we need to impeach him.
Okay, and I assume it's a certified copy that y'all would use if need be. I mean, I guess it wouldn't have to be, but
It's not certified?
okay.
You mean of the transcript?
Yeah,
It's not certified. It's just a,
It's a hallway conversation.
say that again.
It's a hallway conversation. It's not-
Hallway
it's not in
conversation.
court.
it's a
not like
130-page transcript of a conversation.
Oh,
Interview.
it's not a transcript of the guilty plea.
Right, no, it's an
Okay,
interview.
thank you.
It's an interview. That's what I was saying. It's an
Okay.
interview.
It's a transcript of an interview, which you don't assume you'll be using unless you have to refresh his
Impeach.
recollection or impeach him.
Right,
Okay.
that's what I was saying.
All right, no problem. How about this next thing labeled recording?
And let me just say, I don't know what Mr. Arnold's going to testify to or not testify to. To the extent that the state is ever planning on just playing I understand targeted impeachment, but and if I've fallen short of expectations, I apologize, but I have not reviewed this transcript for any extraneous, irrelevant,
Okay.
prejudicial.
And yeah,
things.
and thank you. Y'all don't intend to wholesale use that. If you did, that would be a problem, needs to be targeted. So yeah, just regular old trial evidence. Okay, thank you. All right, and this next thing, which is maybe some sort of a musical recording.
Interview itself.
Ah, okay. I opened it up and it shows a musical note. I guess that's just my media player. Okay. And then this last thing is a picture.
Photograph, yes.
Any issues on this one? No? Okay, moving on to Officer Munson then. Looks like there's another set of crime scene pictures, maybe. And a crime scene report. Couple of crime scene reports. Any issues on those?
anticipate any issues with the crime scene photos.
Okay, thank you. All right, moving on to Jennings Kilgore. We are almost to the bottom of this grouping of 30. This seems to be a ballistics expert.
NIBIN expert.
A what expert?
NIBIN, National
Okay.
Institute of Ballistics.
Okay.
Integration.
He is a ballistics expert with a
Ni-
particular.
NIBIN is different.
It's a
yeah.
big time one, right?
It's the one right before. It's not the actual firearms examiner. So it's a step before. It's a comparison to see if if these have the same characteristics.
All right, anyway, anybody have an issue with the evidence that's going to come in with this person?
I'm sorry, what is this,
This is under, I'm trying to find out specifically where it's under the NIBIN reports. I don't know if I'm pronouncing that right. NIBIN charts. There's a document labeled Operation Planters
Okay.
NIBIN chart.
Okay, I can't open that one either, but
Yes, and that's a summary
okay.
of NIBIN matches that were.
I'm having trouble seeing it in detail, but
Yeah, maybe because the black on the blue is a little hard to read. And we're all old and have old eyes. So is the question just kind of like, what does that say?
What is that?
So those are the chart with the black on the blue. That one is showing that there were 5 shell casings from a particular scene. The black on the blue is the address.
Okay.
The red lines are matches to other addresses where shell casings consistent with the firearms at the previous address were found.
Okay.
And there was, I think that we served in discovery, but I don't think we included in this list of exhibits. There is also an ATF NIBIN examiner that we didn't have in here that they also examined some of these shell casings from different sites. Both Kilgore at the Atlanta Police Department and ATF were all working in conjunction with one another. So
Okay.
there is one more person that will be adding to that, but we'll let them know well before we.
All right, well, if they're going to say the same thing, we don't need them both.
We won't. We won't have.
All right, so with regard to this kind of chart, I guess, now that you know what it is there an objection?
I have one. Oh. Well, here's the problem, Your Honor. And before you were involved in this case, a lot of these prior incidents were Detective Dennis took the stand and the state brought out an easel and they wrote down all these different case numbers and they went through them real quick.
Okay.
On January 26th, 2015, there was a shooting at 841 Smith Street. I'm just making that
Yeah.
up. Okay. And in this, and as a gang investigator, I determined that was part of this beef. Okay. We for a lot of these incidents, we have not heard from any witnesses that collected shell casings. There's been no chain of evidence. There's been no testimony about the collection of evidence.
Okay.
So this is just like coming in without any basis or any foundation, and it would all be hearsay.
All right, is
And
he,
violate the confrontation clause as
okay,
well.
is he going to be testifying that he received the shell casings from each of these and did the exams, or that other person from ATF that you mentioned, or how is this going to get used?
When shell casings are collected, the first person that does that comparison is either Kilgore at APD or they're taken down to ATF to do that comparison. What Kilgore or the ATF NIBIN person would say is this shell casing here was consistent with or had the same general class characteristics as this shell casing over here that was found at this scene, and produce what we call a hit.
Right. So is Kilgore going to be able to testify that for each of those blue boxes, he did an examination or comparison, and that's what he came up with?
Yes, for everyone that we have a match for, either Kilgore or ATF, or Kilgore or ATF did that initial NIBIN comparison. I'm not sure if what the objection is. If it's, we're not going to have him talking about something somebody else did. If that's
okay. So I think one of the objections is that thus far we have not heard shell casings were collected from this firearm scene and provided to Kilgore, and then Kilgore obviously would say, yeah, I got them and I did this evaluation. Is that all of that foundation is going to have been laid in evidence by the time he gets here to testify to this?
Yes, that's why we have the crime scene technicians coming up talking about what they collected.
All right. So it sounds like by the time we get to this, that will have been done.
Be a two-way connection though. It can't just be we collected. I'm using an example. We collected. Certainly, we've had the crime scene, or we will have had the crime scene technician, I believe, from the January 10th incident. So we'll know what was collected, and it was sent to Kilgore, and it was sent to NIBIN, and we get that. But if they're going to say, well, it matches another crime scene, the expert in a lab can't say that unless we know. They can say, I guess, presumably it matched another bullet in the database or something like that. But unless there's a link to an individual crime scene, yes, we collected this and it matches up, that's still based on hearsay. Kilgore or whoever the expert in the lab would be testifying based on hearsay about where that other ballistic evidence was collected from, unless we hear from the person who collected the evidence.
And we would. So I don't know why. I don't know why we're arguing at this level.
We're not arguing. We're trying to clarify. So, for instance, and I can't see them, but the very top two on there, you know, they apparently say, okay, this crime scene A and crime scene B. We will have, and this person, Kilgore, will be able to say, I did a comparison of bullets from crime scene A and bullets from crime scene B, and they're consistent with having been shot from the same gun or something similar. The question on the floor is, okay, will we have already heard not only the chain of custody for Kilgore getting the crime scene A bullets, but the chain of custody for Kilgore getting the crime scene B bullets?
Yes. So we would not have, yes, all of the foundation. I don't think chain of custody, like, you know, specific, like every link in the chain would be necessary, considering we would have the crime scene technician who would have collected it. We would have the testimony that when the crime scene technician has collected it, it comes to my department, mine being Kilgore. This is the case number 150261534. And I compared it to case number X.
Okay, so we will have both, just so I make sure I'm understanding you. We will have a crime scene tech from crime scene B say, I collected all of this and I gave it to the crime lab, or whom, I don't know if this is.
I put it in evidence.
I put it in the, you know, box or whatever they do. And then we'll have Kilgore say, here's the way evidence gets to me, and this got to me that way.
Yes.
Okay. Does
Yes.
that answer your question? I mean, I guess it's yet to be determined whether we will hear all of that evidence, but the objection is going to be, if we don't hear all of that evidence, he can't testify to this. So do you understand that?
Sorry, Judge. The objection is that
If we don't hear the foundation that is both crime scene A tech giving the evidence to Kilgore and crime scene B tech collecting and giving the evidence to Kilgore, and then Kilgore is saying, I got them both in the regular course and I compared them, here's my conclusion, that there's going to be an objection that he can't testify about crime scene B.
And to make certain, looking at the witnesses that we had initially put up, what we can do is add the 10 witnesses from each of those crime scenes that are on this list to make certain that we have each of those links included as
Sounds
evidence.
like that's going to have to happen. Now, it does not need to be, I don't think, a whole as if this were the crime on trial.
It would just be,
It can just be,
hi,
I'm a
I'm
crime
witness
scene
number
tech.
1 through 10 that I'm adding on. I collected
I
this
went
one.
to this crime scene at this date. I collected
Right.
this evidence. I gave it to whomever.
Right.
Which should take 10
minutes.
Okay. All right. She plans to now do all of that. Unless y'all want to stipulate that those bullets got to the crime lab in the normal course from whatever crime scene, which I don't see happening. So, okay. All right. So anything else with regard to Kilgore's, the evidence that would come in through Kilgore? All right. Then our witness number 30 on this list is Underwood. Is Underwood also a NIBIN expert?
She's one of our and detectives and gang experts in this case.
Okay.
And she actually may have been the one, she was an ATF task force agent, and she also would have been instrumental in taking some of the evidence over to the task force versus APD's ballistics lab where Kilgore worked.
Okay.
To have it tested over there.
Okay. Any issues with her evidence?
Yes, because it's going to be repetitive. She is an APD officer, and she's going to be supposedly or potentially the same treadmill of information about YSL and if gang, and this is what the policy is of the City of Atlanta Police, why we qualify people in a gang, and we've heard it from Detective Belknap, Detective Gaither, Detective Dennis. They have 5 gang experts allegedly from the same exact, they work together.
Is this a gang expert?
That's what I said.
She may be a gang expert, but is she going to testify as a gang expert?
I don't anticipate getting into anything overlapping. And actually we were, before this last conversation, thinking of not calling her at all.
But, okay, so she would be chain of custody only?
Some chain of custody. And at this point, I don't anticipate calling her as another expert. But as far as the gang experts are concerned, Your Honor, I just point out that what we've done is announce to the court and to each of the defendants that our gang experts would not be talking about overlapping pieces of information. Every expert was talking about a different point in time as to their knowledge.
Okay.
Detective Underwood had an earlier knowledge of this particular street gang than did Detective Dennis. Detective Belknap testified to a different slice of time.
Okay.
Detective Dennis and Gaither were 2 people who worked as partners during the same period of time. But when we are alleging that this is a street gang that has existed from 2012 up until 2022, you know, during the time of this indictment and even after, and we have every step of the way had cross-examination questions and the rebuttal assertion that this is not a gang, this is just a music label, and none of what you see really amounts to what the state is saying, to have gang experts who have an expertise in particular cuts of time that the gang existed is not cumulative. And the very fact that some of what they say overlaps doesn't in any way make what they're testifying about so cumulative.
I understand. All right, so has this person already testified as a gang expert?
She's not, she's just been
Okay.
qualified as one.
Okay, so you do not anticipate having her testify in her gang expertise role, just as custodian of whatever this evidence and getting it from one place to another then, is that right?
At this point, like we said, at first we were, and then we were
Okay.
like,
All right, and I would think that if for whatever reason you decide that's something you think you need to do, let's address that, because I don't think we need to hear, and I hear you saying we haven't heard the same thing, but we don't certainly moving forward need to hear the same thing. So, okay, that's clear. Thank you.
Your Honor,
Yep.
as the state is announcing that she's just going to be, Investigator Underwood is just going to be a kind of custodian of, or transferring evidence from one place to another, I assume that the operation planner's NIBIN chart and the operation planner's NIBIN leads new chart will not be introduced through her?
Well, none of it's the same or substantially similar to what will be introduced through Kilgore.
I agree. I just noticed
Okay.
that in the
All right.
folder.
Yeah, I mean, they do, again, I don't know why, but I can't open a lot of these on this computer, but is that the same thing or is that something different?
It's a colorful picture showing like a flow chart involving the information that Kilgore has.
Generally the same?
It's all the same information. It's just presented
It's
in
more
a,
colorful?
yes.
I mean, pick one or the other. Okay. All right. Is it easier to read than the other one?
it is.
Okay, well, you can always switch the witnesses that you were going to use that for, but yeah, we don't want to see it twice, but okay. All right, that gets us through the first, our first 30 bucket.
We haven't
No, it
done Mr.
doesn't.
Sprinkle.
Well, yes, other than Mr. Sprinkle that everybody wanted to come back to. All right. Trying to just look back through at things we need to revisit or visit for the first time. Okay, so I think this is a good place for us to stop today. And then, tomorrow, other than the potential hearsay and CAD reports, which we can take up, we can either move to the next 30 and do the same thing with regard to them, because they're going to have to be done at some point when the jury is out. Or y'all don't seem to want to reach the wiretap stuff yet, but as quickly as y'all can specifically identify that and get it to the defense, then we can get to that. I think it'll be easier once they actually have targeted information about that. Yes, sir.
Know why necessarily, but the state specifically identified jail calls for my client as they've stated, which is, I believe, 13 or 14. I've reviewed those.
We're right. Okay, so tomorrow we can tackle
right.
those.
And I'm just warning everyone, other people, not in a, I'll just say it affects.
Alerting everyone.
I'm alerting everyone that it affects more than just my client.
Okay, so everyone might want to take a close look at those before tomorrow. Okay, anything anybody needs to put on the record, make suggestions about for how to be efficient tomorrow, anything like that?
Your Honor, it states exhibit number 55W, which would target the child with the signals.
Okay,
If you can, this 55W has been shown to the jury.
would it be easy for somebody to pull it up on screen for me? And is this just a still photo or is this a video?
A short video.
Okay,
It was played for the jury.
all right. Is Mr. Kokomo going to play that for us, or is he, I don't see him anymore. I think the state's going to try to find it.
Yesterday, I just don't remember that, but it's one that was played months ago. Yeah, you come outside the house.
Okay.
I have another matter while the state is
All right.
helping us. Can I just tell you a case?
Mhm.
Okay, so I believe that my concern about when it's dealing with the RICO conspiracy in Bruton, and then the person in custody is giving a statement, confrontation clause statement, talking about the enterprise, let's say.
Okay.
I have found that my argument has been rejected. And this is the 11th Circuit, United States versus Espinosa, ESPINOZA. It's 635 Fed FED period APPX 739. It's in Division B as in Barry. And it's 11th Circuit 2015. And the 11th Circuit found that we reject the defendant's argument that because the confessional statements may be proof that a RICO enterprise existed, which is a necessary element of the RICO conspiracy charge against both defendants, the statements trigger a confrontation right under Bruton. If the defendants were correct, then any incriminating statement made by one non-testifying co-conspirator would be inadmissible against the other, whether or not the statement facially incriminated the other co-defendant. Bruton's narrow exception to the general rule of admissibility does not extend this far. That's what I found.
All right.
So it's only triggers what we were saying earlier, Mr. Stillwell, Mr. Williams, but I was saying YSL or the
Right.
crew, and I cannot find a case that supports that.
All right. I appreciate you bringing that to the court's attention. Every attorney has a duty to be candid with the court, even if the case law does not favor the argument they wish to make. And so I appreciate that, because I have to say, unfortunately, everybody doesn't do that. So thank you for doing that. Okay, do we have this ready to play? Oh, okay.
That's a sense of lifestyle. Oh, yeah. Sleep, aka bleeding, nigga. Yeah. Man, but mud, we do this every day. Kitchen, and it's behind. Fuck yeah. I put you on the camera. Go on the trench, man. Yeah. Want to give a special shout out to the next company, my niggas, man. Watch you know. Yeah. Big B. Yeah. Little baby rolling B. Little baby rolling B.
Yeah, that's actually the one I was thinking about. I mean, that child starts doing all that stuff unprompted and then maybe gets encouraged to do a little bit more, but I don't think that that shows the same thing as the other piece of evidence that we were talking about. So thanks, but my ruling stands on that.
Can we have a continuing objection if I need?
You may. All right, I'll see everybody at 9 in the morning.
Judge,
Yes.
one thing we did reserve, if you recall, waiting for the order from Judge Glanville on witness number 26, that's Dennis, particularly number 74. We can deal with that tomorrow easily, though.
Great. Dennis, number 74. Mr. Harvey, was that one of the lyrics issues or was that a different item?
Well, it's lyrics, but it's a video.
Okay,
Thank you.
thank you.